all persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3007, United States of America versus Raul Flores-Hernandez, also known as LTO, appellant. Mr. Feichel for the appellant, Mr. Booth for the appellant.
Good morning.
Good morning. May it please the court, Robert Feitel for appellant Raul Flores-Hernandez. Your Honor, I'd like to reserve 2 minutes for rebuttal in this case. During the course of my argument, I am principally going to focus on the argument made in our brief that the government failed to adduce, even by a preponderance, sufficient evidence to establish the leadership enhancement which was imposed on the defendant in this case. If the court were to agree with that argument, then it would not have to resolve the issue as to whether or not my client was eligible for a 0-point offender reduction under 4C 1.1. And in theory, the defendant would have the opportunity to have his guideline sentence reduced from the 39 calculated by the trial court to 31, because he would be safety valve eligible under that analysis. So with that in mind, I wanted to note that I think it is pretty well established, and I don't think it's really disputed between the parties, what leadership requires under the sentencing guidelines for a 4-level enhancement. The parties have not offered alternative, definitions of what's required. It's simply that there be the exercise of power control in a hierarchical way over someone else in the conspiracy, and that the organization consists of 5 persons or more, or be otherwise extensive. And the part that we have focused on in our briefs, and which I want to address with the court this morning, is the issue of leadership in terms of power over other people. I just wanted to note before talking about some of the details that Mr. Flores-Hernandez was charged by indictment with being the leader of a drug trafficking organization called the Raul Flores Drug Trafficking Organization. In the district court, there are no co-defendants. No one else was arrested or charged in this case. And as far as we can discern, no one else has ever been charged in a federal district court case anywhere, not in this jurisdiction or otherwise, who was alleged to be a member of the drug trafficking organization that goes by his name. We think it is a drug trafficking organization of one. And we think that is the problem. We think that fact caused the government an insurmountable problem in trying to prove that he was the leader.
Wasn't there testimony by a cooperator, Pinedo? He was asked approximately how many people in total did you see working in the defendant's cocaine trafficking organization? And he said about 20 people, including around 5 bodyguards. Why isn't that enough?
First, Your Honor, what he said was they worked. Later on, we clarified his testimony, and what he said was they worked with him, not for him. It is in the record. I'll come up with the page in a minute. They worked with him. It is in the joint appendix at page 403 to 404. But independent of the notion that he worked for them, with them, I don't think the case law supports the idea that the mere recitation of a list of people is a sufficient factual predicate to find that there's leadership. First of all, it's too facile.
The question was, how many people did you see working in the defendant's cocaine trafficking organization? And the answer was 20. Why is that not enough?
Because, well, first, later he clarifies it to say that they were working with him and not for him. And I think that the law demands more than a list of people as having worked for you. There's no identification of what anyone did. And more important, to the extent that leadership requires both the exercise of authority over others, there's a recent Fourth Circuit opinion that says that it requires proof that someone followed your orders as well. I think as to both aspects of leadership in this case, the government's proof failed. There was not a single witness who testified that Mr. Flores-Hernandez gave an order to anyone or that anyone ever followed it. So if merely listing a group of people as working for him does not appear to be to us sufficient under the requirements of the guideline to establish leadership. And I think that's because no one worked in his organization.
Can it also be inferred from other testimonies, such as Pinedo testifying that he worked with Flores-Hernandez to store more than 53,000 to 56,000 kilograms of cocaine and helped transport $50 million in drug proceeds for Flores-Hernandez. And he helped collect $14 million to $17 million in drug proceeds for Flores-Hernandez. Can't you infer that they were working for him, or that he had a cocaine trafficking organization just from the quantity and the scale of that enterprise?
So in response, I have two responses. One, in the joint appendix at page 445, Mr. Pinedo Alvarez Correo says, I wasn't a part of this conspiracy. And he specifically and particularly disavowed being a member of any conspiracy. By his testimony, he was simply present watching the goings on. So I don't think that puts him in a subordinate position sufficient to establish that he was a member of the conspiracy. But more to the point, Your Honor, there's nothing to say what the issue of drug quantity and how big Mr. Flores is obviously weighed large in the district court's decisions about this. But there's no case law, there's no jurisprudence that says simply because you were a large trafficker, you were automatically a leader. I think to the contrary, the cases are that labels are not enough, and that even if you were an intermediary, it's not enough absent some exercise of control. So I don't think that under the controlling case law and under the provisions of the guidelines, the mere fact that you were large or that you were involved in lots of cocaine or lots of money movement, automatically without more, it makes you a leader. And I think though there is nothing more in this record.
That it was clearly erroneous, that this factual finding was clearly erroneous. And I just don't see why, even if it's not perfect or precise, this isn't enough.
I can try to articulate it again, but I think that what happened, I think the district court articulated the right standard. I mean, Judge Howell understood what the requirements of the law was. But I think in order to make the leap between the evidence that was presented, which I think really was a paucity of evidence, and the conclusion of leadership, the judge specifically said it's a matter of common sense. And that's what she said in her findings on the day that she ruled that my client was a leader. And I would be hard pressed to say that we don't think that judges should exercise common sense in the rulings that they make, but I don't think it's a fair substitute for a failure of proof. And I do think there was a failure of proof here. And I wanted to go back to that point. Nobody who testified, none of the three government cooperators that were involved in drug trafficking, and they were extensively involved in their other businesses, not a one of them said that they worked for the defendant. They were pretty clear. Mr. Pinedo Alvarez eschewed being involved in the conspiracy. Mr. Jacksinaway Almagay, he said, I never worked for the defendant. And the third witness, who's named Elpidio Mahara, he was the leader of his own independent drug cartel that was one of the largest operating in Mexico. So I think that the failure of the government to identify anyone who actually worked for Mr. Flores caused this failure of proof.
What about Licenciado, Chani, Chachoro, and Enriquito?
Those are people for sure that were identified by the witnesses as working for the defendant. And had the government at the hearing said to the witness, well, what did you ever hear, putting aside the leading nature of the question, which there was problematic in this hearing, but if the government had said to the witness, were you ever present when Mr. Flores-Hernandez gave an order to Licenciado? And you can imagine the follow-up. Yes, I was. No, I wasn't. What did he say and what happened? There's none of that in the record of this case.
That's necessary.
I do think it is necessary. Otherwise, it opens the door. I mean, I'm troubled, as if you've read the briefs, I'm troubled by the nature of the cooperators, and what I see is their incredible motivation to fabricate or at least to exaggerate, because they were beholden to the government for their liberty and for so much more. And they were all, one of them was paid $100,000. But more to the point, if merely listing who you think worked for the defendant is sufficient, then it really does open the door to people basically fabricating testimony against others. And I'm troubled by it in the main, but I'm specifically troubled by it here because there was no follow-up. I mean, it wasn't as though the witnesses weren't in front of the trial judge, and the government had every opportunity to ask, and they didn't ask. And to be absolutely clear, my colleague and I, we did not follow up. We did not open that door to try to help the government. I assume the reason the government didn't ask their witnesses is because the answer was they didn't know. And Licenciado, I mean, it's actual translation is college graduate. It sort of also can be used to be an attorney. We have actually one of a licenciado in the court today, but merely saying A, B, C, D, E, and F, and G worked for the defendant seems to be a wildly insufficient predicate for proof of the essential element of leadership, which is control over another person.
If we can assume that those 4 or 5 people, Johnny, Chicaro, Luciano, Alfaro, and Enriquito, worked for the defendant, I don't understand why it wouldn't follow that they were taking orders from the defendant.
So in the first instance, Your Honor, we do not concede. Oh, I've managed to beat into all my time. We do not concede that they worked for him. And I think one element
The witness said they worked for him.
but without
And the
more.
district judge believed the witness.
Even assuming, for argument's sake, as lawyers always say, saying that someone worked for Mr. Flores-Hernandez is not the same as saying that he gave them orders. I mean, the guideline doesn't say that you're a leader if you have an organization. It says you're a leader if you directly exercise control over someone else.
Luciano paying people who worked at the docks, paying them for Flores. Why would he have done that if Flores hadn't told him to do it?
I think the answer is the government should have, the naked response is the government should have asked, why did he do it? Were you ever present when orders were
We
given?
have precedent saying circumstantial evidence is enough for this sentencing guideline, for this particular enhancement.
Yes, circumstantial evidence would be enough. I think had there been more than the mere recitation of the names of people, Your Honor.
It just seems like either they were doing it because they were told to do it, or they were, I guess, like doing it as out of the goodness of their heart, as sort of like a service project. It seems implausible that you transport money for a drug trafficker for any reason other than you were told to transport the money.
I'll offer a completely, I believe, valid alternative theory. Drug trafficking is no longer soups to nuts. It's no longer one cartel controls everything from the production to its just in Colombia to its distribution and transportation. People use money launderers and they act as independent contractors who do the work. It could very well have been that Mr. Flores-Hernandez contracted with someone to move the money. That person did it, and to facilitate his independent conspiracy to money launder, he bribed people at the ports or elsewhere at the airports to get it done. But that doesn't, without more, suggest that my client ordered it to be done.
So I just want to see if what alternative scenario there is. You might disagree with a bit of the premise of this question, but I'd ask you to kind of go with what I'm assuming. I'm assuming that Flores ran an international drug trafficking operation for 30 years that transported tens of thousands of kilos of cocaine worth millions and millions of dollars. Did he walk all that cocaine across the border himself?
During the defense, the answer is no, he did not. I don't know where
He had to have people working for him to pull off that 30-year multinational operation.
There are two responses. One is of record, which is that he had a business that worked with what they call black market goods. His attorney, during the defense case, we put on the testimony of his attorney, Raul, and he said that the defendant had a business selling black market refrigerators and other household goods. And so it could have been that the money was laundered through that aspect of the business, but it's not entirely clear. And I don't think the burden is on the defendant to prove where the money went or how it was moved. For all I know, for all anyone knows on this record, which is what matters in this appeal, is it could have stayed where it was in the United States. The cocaine could have been sold in Mexico. I mean, they didn't do any deep dive into what happened anywhere because the people that they presented, the government's witnesses, didn't work with Mr. Flores. They didn't work for him, and they barely worked with him. They were one-off events. I think that's the fatal aspect of the government's case for proving leadership. It's that there is no, Your Honor, just again, it wasn't as though the government didn't have three witnesses up on the stand, and it wasn't as though they were precluded from asking. They didn't ask the questions that inure to the elements of leadership.
And I think, as I understand it, there's at least two elements of the sentencing enhancement. One is the organization has to be 5 or more participants or otherwise extensive. And then a second element is that the defendant has to have been in a position where he was telling at least one person what to do. Are you fighting both elements?
As to those issues, I think the evidence of how many people worked for him is de minimis at best, because it is nothing more.
Because you can satisfy that first element with simply an otherwise extensive operation. You don't think this operation was as extensive as an operation with 5 participants?
If the government had adduced evidence, perhaps I would be in a different position, but the government didn't ask any of the details about how this drug trafficking organization allegedly worked. It had the one-off witnesses who were involved in discrete events, and there was no overview. And that flows back to the primal point that I'm trying to make is the government proved this case with people who were not involved with Mr. Flores-Hernandez. And I think that failure prevented them from proving, even by a preponderance, that he was a leader.
There's some evidence that his son was involved in the operation.
There was a reference to his son.
Who did his son work for?
On the record, I believe there is a reference to who his son worked for, and I believe that the answer is a matter that I'm not able to disclose completely in this public forum, but suffice it to say there was no evidence of record that his son worked for him in this organization.
Okay.
My only final comment is it seems that you're saying that we need to have direct evidence and circumstantial evidence will not do. And is there authority for this?
I would be hard pressed to argue that circumstantial evidence is not enough, because everyone who's ever been in a courtroom has heard the instruction about circumstantial evidence being sufficient. What I'm saying is that this variant of circumstantial evidence is insufficient. If simply naming names without further elucidation, I don't believe that naming names without further elucidation carries the burden of proof, even by a preponderance in this case. And again, if there was something here, you would have thought that someone from the government's prosecution team, 3 different prosecutors examined these witnesses. Somebody would have said, hey, it's not as though the definition of leadership changed somehow right before this sentencing hearing. I mean, it's been pretty constant throughout. You would assume the prosecutors knew. No one asked, and I think it's their failure of proof because it's their burden of proof, and that's where we end up in this case. So I have gone over.
That's okay. I just had 2 questions. So one, on the same topic, there was testimony from Alvarez Correa that about this Enriquito delivering money and saying it was on behalf of Mr. Flores-Hernandez, and then unpacking cocaine as well. So that's much more specific than just a list of names. Those are actual activities, and at least testimony that someone said they were doing it for Mr. Flores-Hernandez. Why is that not enough? Is there something I'm missing?
I think in the context of the way the evidence came out, it was not entirely clear, even from Pinedo and Alvarez Correa, that they worked for the defendant. He later, it was somewhat murky, but at the end, he does say they didn't work for him, they worked with him. And again, if unpacking the cocaine had been at the order.
For Enriquito too.
Excuse me, Your Honor?
He said with him for Enriquito.
If they had provided some context and some detail, maybe it would have been enough.
I just wanted to clear, did he say Enriquito only worked with and not for Mr. Flores-Hernandez?
I have to look back at the record, but even assuming that he said he worked for him, without context, it is impossible to conclude that it was a leadership
relationship. The context here is delivering money and unpacking cocaine.
That would be a job that lots of people have who don't work directly for the defendant, because as I mentioned before in response to Judge Walker's questions, trafficking is diffused. It does have different people. This could have been resolved. This could have been easily resolved with questions that probed into who, what, when, where, why, and how. None of that was elicited. That required the district court judge to sort of resort to the well, common sense tells me that because of the quantity, he must have been a leader. I just want to point this out. Let's assume in a hypothetical that there's been a lot of press lately about the United States blowing up what they call fast boats in the Caribbean off the coast of Venezuela. But there are lots of other defendants who were caught on those boats under the Maritime Drug Law Enforcement Act, the MDLEA. So under the judge's thinking, if you were a member of a crew and you were in a fast boat that was traveling undercover at night, and there were 300 kilos in the boat, that you would also be a leader if quantity is the sine qua non of leadership. That obviously is not the case. People that are members of those crews are the lowest ranking levels of the conspiracy. Although I should say that there are times when boat members become leaders too by simply saying to someone else, could you get the tuna and the water, for the boat crew? But I think the government is obliged. This was a case in which we contested all of the guidelines. This was not just this one. We contested a lot of the other ones and we had success. But I sort of felt like the judge was going to give one for the home team. But I think that, the government has the burden of proving these matters. I mean, they allege that it was true. And I think this is, to the extent that there were any sort of single points of evidence about this issue, even whether considered solely or independently or collectively, I don't think they rise to the level even of preponderance in this case.
And I just had a question on the drug weight that you had contested in your brief, but Mr. Flores-Hernandez pled to selling cocaine up to 450 kilograms. So why do we have to get into that whole issue of who should be credited about what just on the drug weight?
I'm going to leave it to the briefs. I understand Your Honor's point. I think it is 450 or more. So it was within the range that he agreed to in his statement of facts. So, and I did not make much in my rebuttal brief nor here about quantity.
Just to make sure I'm clear on that. Okay. Any other questions? We'll give you a few minutes for a rebuttal. Thank you.
Thank you, Your Honor.
May it please the court. The district court correctly found that Flores was the leader or organizer under section 3B1.1A, and there's three primary interrelated reasons for that. I'd like to start them in sequence. Flores was a major cocaine trafficker. He was responsible for 53 to 56 kilograms of cocaine, and he paid a portion of those proceeds to the Sinaloa cartel. The district court found, and this is on page 246 of the joint appendix, that Flores had deals with multiple high-level drug dealers for hundreds of kilograms of cocaine. That fact, which in our view is not clearly erroneous, maps into the decision-making authority, the claimed right to a larger share of the fruits of the crime, and the nature of the participation in the offense factors in application note 4 to 3B1.1A. Second, the district court found that Flores discussed supplying planes for drug dealing to Ramirez, and they also discussed drug shipments involving kilograms of cocaine in January 2017. That's a joint appendix 221 to 222. That fact maps into the exercise of decision-making authority and the planning and organizing the offense factors in application 4 to guidelines 3.1.
I think the prong that they're contesting is the demonstrated an exercise of leadership over at least one person, which I don't think these points go to. So I think that's the one that we've been focusing on, unless my colleagues feel otherwise. As to that, this was a very strange case for the government. I mean, as you said, there were no witnesses. Despite this very, very vast organization, there wasn't a single witness who said, I worked for him. And the testimony, maybe some of this was translation issues, I don't know, but it's the government's burden, was really rather elliptical whether people were working with him or for him. And it was all, and you had witnesses who, again, themselves only had sort of fleeting interactions, if at all, with Mr. Flores-Hernandez, and then were sort of elliptical in their testimony. So it just seems to me that very strange if it's so big that the government couldn't find one person that actually says, I worked for him.
That was going to be my third point. And
Okay.
before I get
Sorry.
into that, no, that's all right, Judge Millett. The question that has been raised about whether I worked for him or with him, I would like to quote from the transcript to point out exactly how that came out. And this is on JA 403. And it said, did the defendant have workers or people who worked for him who would receive his portion of the cocaine? The answer is yes. Now you go back to the next page, and then the question is, were any of these people related to the defendant? And it's at that point that the witness says, no, they worked with him. Well, our submission is that particular with him really doesn't count for a whole lot, because the question that was being asked to him at the time was, were these people related to him? This witness wasn't being asked to give a formal definition between workers for or with for purposes of deciding whether or not there was supervision under 3P 1.1. So we give absolutely no weight, and we think the district court properly gave that no weight, even though he didn't do it directly, in discounting the they worked with him sentence. Again, that's on JA 404.
You also have to show, to get this leadership enhancement, that the person that was managed, that he was the leader of, was a participant in the enterprise, and participant has a specialized meaning. That is, you have to show that every element of the crime, including mens rea, was met as to those persons. Where did the government do that?
There was a lot of circumstantial evidence that many of the workers for Flores knew what they were involved with.
So when you have someone say 20 people worked for him, that doesn't do anything to establish the element as to any individual, including, of course, most particularly mens rea. A lot of people could work for someone without, in other capacities, errand boy, bodyguard, without knowing what the operation is. So what evidence is there of mens rea as to one of these participants?
Well, I am talking about, there are two particular facts that are involved here that, with respect to supervision. He supervised Pinedo, who not only cleaned the tanks containing the cocaine that was delivered to Flores and his brother, and that's a factual finding at 215, but he also shipped $50 million in drug money back to Colombia for Flores, and that's a finding on JA 216. Now, if Pinedo is shipping $50 million back to Colombia, he knows what he's in for. You're not shipping $50 million.
Did Pinedo work for him? Did he say he worked for him?
Pinedo,
He had his own sort of, they were sort of working with each other.
well, but remember,
Tag teaming.
Pinedo stated that he was cleaning the tanks, and of the tanks that came out of the cocaine that was coming out of the tanks, half of it went to one of his relatives and the other half went to Flores.
No,
And
I get that. I'm just asking if you can point me to the testimony record where Pinedo says, I worked for Mr. Hernandez, as opposed to I had my own operation. This is what I did. I got stuff in and out of these boats. I had my relationships on the docks. I got it out. I did this much for this group, this much for this group, which sounds like he's sort of an independent contractor. But if there's something that says he was for working in that capacity, working for Mr. Flores-Hernandez.
I cannot point you to anything in the record in which any one of the three witnesses said that I was working, well, that where Pinedo said I was working for him using that particular language. But again, the circumstantial evidence is, on the one hand, he is cleaning out the oilers, the tankers that contain the cocaine, of which Flores is getting half of that, and that's 1,000 kilograms per pop. And then later on, he's shipping $50 million in drug proceeds on behalf of Flores. And I believe that's the finding that the district court made at JA 216. So if you take those two facts together and look at all the circumstances in this case, I think that the district court's finding a fact that this Pinedo was working for Flores is certainly not clearly
Can I
erroneous.
just ask one clarification? Because this might be, I don't know that common law employment concepts map onto here. So your friend on the other side has said, look, the way these things operate is people all have their different roles and they just have relationships and, contract with somebody to do the shipping or collecting the money for them or laundering the money. Do we know, for purposes of this guideline, if you contract with somebody to, say, carry your your cocaine across the border or put it on a ship. Does that count as working for someone? Does contractual relationship? Or do you really have to be what we would in a sort of common law sense think of as an employee? I don't have any idea what the case law is.
I'm not sure. This court has said over and over again that you have to have some control over another person. It hasn't.
Control over people who come
Right.
paint your house.
That is true, but it has also said with respect to leaders as opposed to managers or supervisors, they're more involved in the strategic planning than the day-to-day operations.
Right, I'm just still, but I'm
Right.
just asking, let's say Mr. Flores-Hernandez's view is correct, that he had his thing and then he worked with this person. You're the launderer, you're the transporter, you're the bribe payer. And so at some level, they're sort of equal level people. On the other hand,
Mhm.
he's paying them to do something for him. So does that count for the?
If he's
guideline?
paying them, again, the words that are used in application note 4 are control and authority. And our submission is that, for
That's what I'm
example,
asking, is does control and authority include having someone agreeing to do work for you? What, if we might look at it as an independent contractor, but they're still agreeing
say
to work
that-
for you?
I would say there's elements of control there. And in this particular case, again, we're not talking about Pinedo delivering $2 to the Colombian drug dealers. It's $50 million he's doing for Flores. And I think a district court can find, this is not an edge case, Judge Millett, where you're delivering $50 million to somebody. That person, Flores, has control over you. And there's another person involved. I only have 30 seconds left. There was, for example,
And the court asked straight up the government whether any of the cooperators were working for Mr. Flores-Hernandez, and the government agreed they were not.
I know what, wait, I don't have that exactly. I believe that the testimony that, based on the district court's findings, on around 215 or so, J214, that he found that they were working for Mr. Flores. And one other person they mentioned, he definitely supervised Chicklin. Now, Chicklin was the individual who drove the truck that had the $14 million in drug money that Sinaway had helped unload from the warehouse. Now, they took the $14 million, they put it in a truck, and it was delivered to Chicklin, who was going to give it to Flores. Well, if Flores is not supervising Chicklin,
Because in the court said, it's a little indirect, but any of the cooperators were not included in the 5 because he wasn't, by their own admission, this defendant wasn't their leader. That's correct from the government. So the government admits that none of these 5 cooperators were under Mr. Hernandez. Flores was not their leader. Flores-Hernandez was not their leader.
I would, again, the district court made findings of fact with respect to the individuals who were working, whatever the government said earlier. The district court findings are not clearly erroneous. And again, in addition to the supervision aspect,
All
which
right,
is one.
I'm sorry. I just want to make sure I've got this right. If your argument is that one of these cooperators said what he did, that he was working for Mr. Flores-Hernandez, the government disavowed that, and the district court cannot credit something the government disavowed.
The district court did credit the testimony of Pinedo and the that there was.
On lots of things, but not as to whether any of the cooperators themselves worked for Mr. Flores-Hernandez. The government disavowed that.
Well, but the government's, our position here is that there was sufficient control and authority. The district court made that finding, and that's not clearly.
Where's the district court's finding that the cooperators worked for Flores?
Any one of them.
I don't have that finding right in front of me.
But JA 243 is where the government says that's right. None of them worked for him.
If you can find where the district court found it, Mr. Booth, I'd still be interested, because we may, and maybe that we would all agree on this, but I'm not sure that the government could waive away a fact in the record if the district court then finds that fact. But it it's not clear to me that the district court even did find the fact you're saying they did. So I'd be curious to know where the fact is.
I would have to relook at it again. I don't have it right in front of me, but I do have again on JA 245 and 246 that the district court says that the government names individuals supervised by the defendant. And then he says that Sinaway testified that the defendant had numerous workers but was unable to name any. And then the district court then makes the finding at JA 246. Not only did the witnesses identify by name more than 4 workers, 5 workers supervised by the defendant, his narcotics trafficking qualifies as another spy's extensive illegal operation. So the district
So
court.
that's different. I think we're mixing apples and oranges here. Because I think what you're saying is that these cooperators testified about other people who worked for Mr. Flores-Hernandez.
They
And
testified.
that's what the district court credited. I was just trying to make clear that the government said you're not claiming any of the cooperators themselves worked for Mr. Flores-Hernandez, and that's what the government agreed. None of them did.
I would agree that again, with respect to Ramirez was not under Flores's control when they discussed.
All cooperators.
Right. But he was not under his control. So Ramirez was the leader at one point of an earlier cartel, and he and Flores discussed planning
Mr.
to.
Booth, I don't know why you're disputing this, because it doesn't matter, does it, whether the cooperators worked for him, as long as somebody did.
Well, I agree with
Not
that.
really
I may have misunderstood Judge Millett's questioning, but I think
It
there's.
costs you nothing to concede that the cooperators didn't work for him, but they provided evidence that other people did.
I would agree with that, except I may have been confused by Judge Millett's question. I apologize for that, but I think there's certainly sufficient evidence here based on the district court's finding that Mr. Flores did supervise a number of individuals in this case. And it is not the case that the witness testified that they merely worked with him instead of for him. That was in response to a particular question about whether they related to the defendant.
There you go again. Why, to Judge Millett's question and to Judge Payne's question, why not either say the cooperators, there's not evidence in the record the cooperators worked for him, or point us to where in the record the evidence shows, and in particular, that the district court found that the cooperators worked.
I will agree with the first one, that the cooperators did not work.
Okay.
I was a little confused by your
Okay,
question.
sorry
I was-
about that.
No, that was my error, but I was going to say I would rely again on around pages 245 and 246 of the joint appendix.
So do you think is the person who worked for Flores, that's, if you could just pick one person, it's like this person is the best evidence we got that Flores was in charge of somebody?
Well, he was definitely in charge of Chicklin, because Chicklin, for example,
That would have been my guess.
my guess, because Chicklin,
What did he tell Chicklin to do, and what did Chicklin do?
yeah, what happened was that Chicklin was responsible for taking the $14 million that Sinaway and his father had unloaded out of the warehouse, and he put that in the truck, and that was going to be delivered to Flores. So he definitely supervised that individual.
And,
Yes.
and one of the cooperators said Chicklin worked for Flores.
Yes. And the district, yes.
I also think on JA 408, there's a lot of testimony about bodyguards. And the question was, how many people in total did you see working in the defendant's cocaine trafficking organization? Answer, about 20 people. What are the variety of jobs or tasks that they did for him? They were bodyguards or people that worked for him. And then there was more questions. How many? There were 5. What, if anything, did they have on them? I never saw anything on them. They were talking about weapons, but I knew they protected him. That seems to be people that worked for him.
Well, again, the district court did refer to the 5 bodyguards in its findings.
Is there mens rea? Did the government have evidence of mens rea, that the bodyguards and these other unnamed 20 people that worked for him themselves, any one of them individually met the definition of a participant, which is what.
There is no direct evidence that in the record.
Okay, what's your indirect evidence? That
Indirect
any of
evidence.
Those bodyguards or the 20 people that are unnamed as to mens rea. I mean, you could have somebody who mows the grass, right? You can have somebody who does the dishes, does the cooking, cleans the house. And that's normally not going to be enough. That's not enough for the enhancement you have, unless you can show that that individual met every element of the crime, including mens rea.
I would say it's a
That's
fair.
the problem with the vagueness of the 20.
I would argue that circumstantial evidence is if you're a bodyguard for a drug dealer, you probably have some idea why you're bodyguarding him. Now, again, I will recognize, Judge Millett, there was no direct evidence in the record. But again, the judges could make inferences.
Well, bodyguards must know, the government gets to say, I mean, they could know he's a super rich person. There's a lot of testimony about his great big house. He's a super rich person living in a very dangerous area of the country.
But looking at the evidence as a whole.
Everyone who has bodyguards is not because they're engaged in criminal
That's-
activity.
That is true, Judge Millett. But I think, again, if you look at the evidence as a whole there, look at who they were bodyguarding him at his palace where he was having parties. And as Flores said, he was bringing in all the drug suppliers. Again, that's just one little bit of evidence.
I mean, look, there are plenty of celebrities that are going to have bodyguards at their big mansions and their big parties. It really is the government's job to sew this up. So I think that is not your strongest ground at all to be relying on for meeting this element. Because the government just didn't do anything to sew it up.
Well, again, I emphasize again, as I mentioned to
Did
Judge
Judge Howell
Walker,
assume that the bodyguards had mens rea?
she didn't make any mention of
Okay,
that.
so we
in
don't
the
even have a
findings.
fact finding on that we can credit.
Right, but as I mentioned to Judge Walker, I think the most important supervisee in this case was Schicklin, because he was taking the money that
Where's
came
the
from the warehouse.
testimony about shipping?
I believe it's at JA 709. The finding is, I believe, is at JA 245.
We're on 709, or the next pages is your best evidence of. There was lots of money.
If I'm wrong on that, I will correct it in a note to the court. But I believe at JA 245 is where the district court makes the finding about Schicklin.
I guess it says, Chicklin was going to pick up the truck and deliver it to Mr. Flores.
Then he said, did you get paid? And he says, not really. It was my family business. I wasn't on the payroll per se. It was my stepfather's business. So it sounds like he was working for his stepfather.
Well, the 50
That's not
million,
Chicklin.
That's not chicken.
That was the witness, right?
And Chicklin didn't testify.
He mentioned Chicklin. The witness is talking about Chicklin. So the witness, it was his
Okay.
family's business, but
Got it.
he
Thank
doesn't
you.
say much about Chicklin, though.
I do have the citations in my brief with respect to Chicklin, even though I don't have exactly the whole transcript right in front of me at this point.
I mean, I was just looking at the record as I was sitting here and saw on page JA 405, there is some detailed testimony about Licenciado and about what he would do on behalf of LTO. He was in charge of all the loads that would arrive and be delivered. He was the one that would get a hold of the people that had to work. He was arranging or getting people to work. He was the person who would pay everybody at the ports and wherever they would be working. I guess you could infer mens rea from that.
And my impression is that the vehicle that on 709 that Chicklin picked up, he wasn't just picking up a vehicle, he was picking up a vehicle with $14 million
Yes.
and bringing that $14 million
To
to
Flores.
Flores.
So our view is that Flores was definitely supervising him.
We call on 7-Eleven, they call him provider. Mr. Flores paid as providers. Probably know Chicklin wasn't a provider. Right? Right? It's a chain. You receive the profit from yourselves and you need to pay your providers and your bills. It's just another business. Do you have an idea how Mr. Flores paid his providers? Everything was in cash. So I'm back to my question, are providers Do providers count as?
It would depend again on what exactly.
Let's say, Mr., I don't know, it's really confusing testimony. Let's say Mr. Schicklin has a business providing money delivery services or campaign delivery services. Is that sufficient? Are you aware of any cases that have said that type of relationship is sufficient?
I haven't seen anything specifically on that point. But again, I think in this particular case, the district court could have inferred that when Schicklin was taking that several $1 million in a truck that Sinaway and his grandfather had taken out of the warehouse, that was drug money and that he was working for Flores at that time. And that's a perfect example of supervision in this particular case, in addition to all the other leadership traits that Flores exhibited in this case.
Can you take a look at 711, J711, the reference to providers? I think they're not saying Schicklin was a provider. I think
I'm sorry, I don't have that record right in front of me on 711. I don't.
JA.
I don't have it in front of me now.
So what did Schicklin do for Mr. Flores? Answer, like everything, a little bit of everything. Question, do you know what he was going to do with that cash after he picked it up? Answer, not really. I think just deliver and pay to, I really don't know.
But the whole purpose of having Sinaway and his father unload the money in the warehouse was to give it to Flores.
I'm just like, if somebody is working for me, it better be quite clear to them what they're supposed to do with it. This guy doesn't seem to know for sure what he was going to do with it. Okay. Any other questions? Thank you very much, Council.
May I proceed, Your Honor?
Yes. Guys, we'll give you 2 minutes.
I will be brief. I wanted to say that I think this conversation and delving into the sort of really minutia sort of exemplifies why the government failed to prove a leadership on the part of Mr. Flores-Hernandez. And I did want to refer the court to, I believe it's the commentary with respect to the leadership enhancement. It says that titles are not controlling. I mean, titles labeling someone boss or chief of operations is not sufficient. And I think in the same way, the witnesses labeling other people as workers is insufficient, absent some kind of factual predicate. I read through the Schicklin testimony. I mean, he picked up the money and the witness doesn't know what happened to it. And even then, it's not clear that that person identified by the nickname Schicklin was working for Mr. Flores-Hernandez. The government could have said, do you know what the relationship was? Did he work for Mr. Hernandez? For all we know on this record, he was an independent contractor doing it for his own business, and that he wasn't going to get paid unless he delivered the money. It is impossible to understand. As to the original comments.
So hypothetically, I want to like ding the independent contractor analogy here, but I'm not sure it totally translates. I think in terms of command and control, usually it's the person who receives wages that is being directed, and it's the person who pays the wages who is doing the directing. And it seems like this cooperating witness had $14 million that was owed, needed to get transported to Mr. Flores. And the testimony was Schicklin worked for Flores and Schicklin transported the 14 million from this cooperating witness to Flores. So again, either Schicklin did it because he just likes to drive around for fun, or he did it because Flores was paying him to transport that $14 million of Flores's money to Flores. And if he was paying him to transport it, which it seems like he had to have been, that's one person who was being directed by Flores, and it's a participant with the mens rea because you know that if you're bringing $14 million in cash, very high likelihood it's illicit.
Your Honor, I'm going to disagree as a sort of an overarching factual matter. I do think that the independent contractor analogy is equally likely in this scenario as it is that Schicklin worked for the defendant. there is an absence of proof as to the nature of the relationship between them, other than the vague designation as a worker. We don't know if Chicklin was hierarchically. The money launderers sometimes are hierarchically superior to traffickers because the purpose of drug trafficking is to collect the money. If you don't have someone to move your money, you're basically out of luck.
Do you have any case that says, this is what I was trying to ask government about, says if that you contract with somebody to do this money delivery or cocaine delivery service for you, that is not sufficient under the guidelines? This is just, we're not engaged in employment relationships here at that level of care that we do in civil cases. And I'm just curious as to why it wouldn't be enough that you hired someone and paid them to do this job for you.
So in the appellant's reply brief at page 6 to 7, I cite a number of more recent cases, including United States versus Martinez. In the parenthetical, I noted that the court concluded that evidence that the defendant orchestrated drug shipments, was involved in wire transfers, and, quote, utilized other persons to mail and receive drugs was not enough to establish leadership. And before it is a case from the Seventh Circuit, which talks about how an aggravating role adjustment is not appropriate for a middleman.
When you say Martinez, do you mean Martinez Vega? Just want to make sure I'm on the same case as you.
No, I said United States versus Martinez. The citation that I have in the brief is 584 F 3rd 1022. It appears at page 7 of appellant's reply brief.
Okay, I appreciate that.
And there's another case that appears on the preceding page about aggravating roles in middlemen. I think that the idea that everyone had to delve into the woods or the weeds, so to speak, as to what Chicklin did and speculate, really, because that's what it is on the record before this court, as to how he got paid and what the relationship was, is prima facie proof that the government failed to establish the leadership enhancement in this case. And I think I have looked at this record. I participated in these hearings below. This is the only case I've ever seen in which the government didn't call someone who said, yes, I'm not saying it's required that you find somebody to work for the defendant. I mean, obviously you can't, no one would have that as an absolute requirement in the law. But if you're going to call someone who didn't, and I reviewed the page that Judge Millett referred to, the government specifically eschewed the idea that these 3 cooperators worked for Mr. Flores-Hernandez. So if you're going to call someone outside the parameters of the case, I think it ought to be obligatory on the government to actually prove its case by more than titling people as workers and more than vague generalities about what they may or may not have done. I think that the law demands more.
You thought the government's proof was so weak. Why did you guys plead to the information? Why didn't you just take it to trial? Put them to the burden of proof. Maybe they had other evidence that they didn't bring up at a sentencing hearing, which is, a different standard of proof. It could be more summary. They might have had other evidence that they didn't bring, but I don't know that this is relevant, like at the sentencing stage, to say like, oh, their proof was not strong because these are cooperators who did not work in this organization, that they're not required to bring people who worked in the organization. Maybe they had people who did, but they didn't bring them to the sentencing hearing. And if you think that the evidence was so weak, why did your client plead to the information?
The client made the strategic decision to plead guilty to the indictment without an agreement because he would not accept the majority of the enhancements that the government tried to insist upon. That is for bribery, for using airplanes and the like, which the district court denied. As to the position as to whether or not the government had other witnesses that they didn't utilize for the sentencing hearing, that could very well be the case. But the burden is on the government. The burden's not on the defense to disprove it. The government failed to do so.
I'm just saying that the burden is preponderance of the evidence. It's a much lower standard than at trial. And you come in and say that they had a weak case, but you pled to the indictment.
Yes, on the merits for 5 kilograms or more of distribution, the defendant did not admit to leadership in his declaration. He specifically said that he was an intermediary, which is in the statement of facts that was presented before the district court, and that's the position that we continue to take before this court because the government has not proved to the contrary that he was anything more than an intermediary. And the size of the amount of drugs and the quantity of money that gets moved is not, I don't think, in the context of the evidence adduced at this particular contested sentencing hearing, sufficient to satisfy the government's burden of proof, even at a preponderance.
The forfeiture that you conceded to would have meant, do you remember how many thousands of
No, the judge, I think, imposed in the millions because it was fairly,
millions of dollars?
yes.
And then thousands of kilos.
We did not agree, not to interrupt, we did not agree to the amount of the drugs. We agreed to the amount of the forfeiture.
Yeah, but that's just math. You just divide the amount of the forfeiture by the value of the drugs.
True, but I don't believe that the admission of the acceptance of a forfeiture order automatically is an agreement to the underlying quantity of drugs. And we're not really arguing about quantity of drugs here. If the underlying forfeiture, I think, order bears on nothing on leadership.
It's your position. I think the forfeiture is maybe $23 million, but I can't remember for sure, that someone can traffic $23 million worth of cocaine single-handedly.
Is that my position? Yes, you could be an intermediary. Someone who's a point of contact for buyers and sellers could easily be involved in hundreds of thousands of kilos of cocaine in millions.
Maybe like the corner boy or the courier on the Swift boat. But I think to be there's no information that he worked for anybody. So
I think he was on my position, I think the record is that he was a cartel of one.
okay.
Any other questions?
Thank you very much.
Thank you very much to both counsel. The case is submitted.
Of course.
Case number 24-1360 et al. Vermont Information Processing, Inc. Petitioner versus National Labor Relations Board. Mr. Ellis for the petitioner, Mr. Sauter for the respondent.
What do you?
Good morning, Your Honors. May it please the court. I think I've reserved 2 minutes for rebuttal. I'm Steve Ellis. I represent Vermont Information Processing. We're appealing a decision of the National Labor Relations Board that was issued on November 5th of 2024. It relates to the termination by my client of 4 software developers. Mr. Bendel was terminated on February 16 of 2021. The other 3, Mr. Dragoon, Mr. Swift, and Mr. Noble, were terminated 2 days later on February 18, 2021. I'd like to focus on 2 or 3 issues which potentially moot all of the other issues that have been raised in the briefs. And the first is the issue of uncharged conduct. The general counsel's complaint alleged that my client, VIP, fired all 4 of the charging parties because they, quote, engaged in concerted activities with each other and with other employees for the purposes of mutual aid and protection by creating and disseminating a spreadsheet where employees could view and share salary information. But, Your Honors, neither the ALJ nor the board found that Mr. Dragoon, Swift, or Mr. Noble were fired for that reason. The ALJ found and the board affirmed that those 3 were fired for their chat communications on a VIP work platform after the spreadsheet had been created and disseminated. General counsel never moved to amend the complaint, either before, during, or after the ALJ hearing, to charge that these chat communications were concerted protected activity, or that firing those 3 for those chat communications violated the act. This theory appeared for the first time in the ALJ's decision itself, and that's at Joint Appendix 1739. VIP argued to the board that the ALJ's finding of a violation that was not charged or litigated violated VIP's due process rights. The board's decision doesn't address that argument at all, and this is a very fundamental constitutional problem. This court has repeatedly held we cannot affirm a decision made without a reasoned explanation. Without a reasoned explanation, it's impossible to determine whether the decision is supported by substantial evidence.
Isn't the standard that it is well settled that the board may find and remedy a violation even in the absence of a specified allegation in the complaint if the issue is closely connected to the subject matter of the complaint and has been fully litigated?
Well, that may.
And it seems to me that what the ALJ did, it was closely connected because it relied on the chat that was closely related to the spreadsheet and Bendel's firing, which allegedly was because of the spreadsheet. But I think what is a little bit more problematic for the board is that the NLRB cited workplace conditions. And I'm not clear on how that is something that was closely connected and fully litigated.
Well, I'd like to get to that in a moment, Your Honor. But the problem is the board didn't address this constitutional due process argument at all. And this court has held that a board decision is arbitrary if it fails to consider an important aspect of the problem. And this is an important aspect of the problem that we raised in our briefs to the board, that this is a violation of due process.
But it's not a violation of due process, is it, if it's closely connected to the subject matter of the complaint and has been fully litigated?
But we don't know what the board decided on that issue because they didn't address it at all. So it's an unreasoned opinion. We don't know if there's a reasoned explanation for it or an unreasoned explanation. There's no explanation for the board's failure to address.
But it would wouldn't it be harmless error if there was no due process violation? It would be harmless error for the board to have not addressed why it was not a due process violation.
I don't think you can get there, Your Honor, because the board has to address this problem. But let me get to.
They adopted the ALJ's fine. Any that they didn't disagree with, they adopted in full the ALJ's findings, which means they adopted the ALJ reasoning that Judge Pan just referenced.
Well, they
didn't grapple with.
They didn't specifically adopt the
They adopted more specifically when they say we adopt everything that the ALJ said, except, and then they have some footnotes. They adopted everything the ALJ said. So they did address it. They just addressed it in a way that they're entitled to address. District courts do it all the time with respect to magistrate judges.
Again, Your Honor.
And so that's the way they do it. We adopt what the ALJ said.
Again, Your Honor, this was a very important argument that was raised before the board, that this was a.
They answered it. It's not important, not important. They answered it. They said we adopt the ALJ's findings. Your whole argument to me so far has been they didn't address it. In fact, they did address it when they adopted the ALJ's findings.
I don't believe that's a reasoned decision, Your Honor. And
Okay.
this court.
If we're going to adopt, this is going to be like a thunderbolt decision. If we were to say the board cannot address or respond to arguments by simply adopting the ALJ's decision on all arguments raised except the ones that it specifically disagrees with. Do you have any precedent for that?
They addressed some and they didn't.
All the time.
I understand, Your Honor, but this court has held repeatedly that if it's an important argument and the board fails to consider it, it can't be affirmed. It's arbitrary.
If they say we've looked at how the ALJ dealt with this and we adopt its findings, that is considering it.
I don't believe that's a reasoned decision, Your Honor, and on an issue of this importance. But let me get to the issue that Judge Pan raised. The board's decision found that not only were these individuals terminated, not for the reason that was charged, but for their participation in a chat that discussed workplace conditions without discussing what workplace conditions the board determined to be protected activity.
Isn't it obvious that the workplace condition at issue here that's tied up with the spreadsheet is the concern about getting underpaid?
Well, there wasn't a charge here that being concerned about being underpaid.
And that's what was so upsetting on the spreadsheet. And that's what they got upset about from Mr. Bendel was the spreadsheet had that line about, developers underpaid 100%.
But the charge, Your Honor.
That's a workplace condition, right?
The charge didn't charge that complaining about being underpaid is a protected activity.
It was the content. It was the content of the spreadsheet.
But we can't, Your Honor, we can't tell from the board's decision, the workplace conditions that were discussed in that chat were,
Says to Mr. Bendel's firing, J1053, Mr. Simard did not like that the spreadsheet conveyed the message to everybody that the programmers are all underpaid. That was his firing for the spreadsheet because it conveyed the message that all programmers or developers are underpaid.
but Your Honor, the board's decision doesn't say which comments in the chat about workplace conditions were considered to be protected activity.
All we need is one. And if they're definitely, the whole rationale for firing Mr. Bendel, the whole rationale that they were discussing was this concern about underpayment. It becomes self-evident. We don't require, jot and tittle like that.
But Your Honor,
There's one workplace condition that they were talking about.
they were talking about lots of workplace
Yes, but it
conditions.
included, one of them was concern about underpayment. And then Mr. Bendel got fired for the spreadsheet that included this line about underpayment.
But it wasn't complaining about underpayment that was the protected activity. It was salary sharing. It was the active salary sharing that was the protected activity that was charged. Mr. Bendel had been complaining about being underpaid for months. That was not the protected activity.
We got Mr. Simard himself telling us that what he didn't like about the spreadsheet was that not that it was a spreadsheet of salaries, but that it conveyed the message to everybody that programmers are all underpaid. That's what led him for the charge for firing Mr. Bendel.
But the workplace
Is that a
conditions,
workplace condition?
it might be, but what's also workplace conditions is the discussions in the chat that actually were the reasons that were why these three individuals were terminated, where they were saying, we're all leaving. We're trying to take another talented developer with us as we're leaving. They're saying, purge your computers. Nobody's disagreeing with that.
Okay, the district court discredited as pretext the concern about purging computers. And I assume your company doesn't have a policy of firing people when they say, look what's happened, we're going to think about leaving.
That's not all that happened here, Your Honor. They said, we're leaving. We're trying to recruit another developer to go with us. They're talking about these are highly skilled computer software engineers. They have access to the company's most sensitive IT infrastructure and data. They're trying to roll out a new restructuring of the development teams, and they now have three developers who are saying, we're on our way out the door. We're trying to take another developer with us. They're talking about purging their computers. One of them says, I'm downloading this confidential VIP document onto my personal Google account.
I guess I'm trying to understand here is the stuff about purging, the ALJ and board both discredited as pretext. So that's just not the basis for their firing. If it was pretext, it's pretext. It's not the basis for the termination of those three employees. And there was plenty of testimony that Vermont Info did not discourage people from looking for jobs if they were unhappy.
Well, there's also plenty of testimony that Vermont Information Processing didn't discourage people from sharing salaries either. And
Right, that's
the
what you
administrative
said about the workplace condition of underpayment. That was the trigger.
But the administrative law judge's finding on pretext was basically just the ALJ disagreeing with VIP as to what level of risk should be tolerable.
No, I don't. No, I think that's not fair. That is not fair. They said there was no indication whatsoever that anyone checked to see if computers had been purged ever, that was not examined like you would if you thought somebody was purging computers. And the one person who said purge your computers, boys, was Mr. Noble, whom everyone said was the hardest decision to make on termination. The other two didn't say it, didn't do anything. So they weren't purging anything. They weren't encouraging it. They didn't do anything, and their computers weren't examined. That is much more rationale than you're giving the ALJ and the board credit for.
Your Honor, the VIPs had software installed to monitor the systems perpetually. Some bugs that may be placed in the network, either intentionally or inadvertently, could be undetected for some time. The testimony was we monitor these things constantly. The fact that we haven't discovered any problem right now doesn't mean there might not be a problem. And why should we be retaining software developers who need to be entrusted with this level of access to our IT infrastructure and data if they're telling us
the stuff that's been rejected evidentially is a basis for termination? Mr. Simard said as to these three, if you have one or two people poisoning the well and telling employees that they're underpaid, it starts to resonate further and undermine the happy culture he hoped to cultivate.
yes, and if you have
That's reason for termination. That sounds like it's very interwoven with the spreadsheet and very much a protected activity.
Your Honor, but it's not the protected activity that was charged. And
Someone is charged with an unfair labor practice. Let's say they're charged with preventing people, and I don't want, talking about, I don't want to do the salary thing because of that, but talking about safety concerns on an assembly line and they're discharged, and that's an unfair labor practice. And the company comes in and says, oh no, we discharged him because he was forming a union. Can the board then credit that and say, well, either way, it was an unfair labor practice?
well, the company never said
Can the
that.
company, I'm not saying you said that here, to be clear. This is a hypothetical.
Right, no, I
There's no
understand.
evidence that was said here at all. But if you have a charge on one thing and then the defense evidence comes forward and shows, in fact, the termination was for a different unfair labor practice.
Well, that's important, Your Honor, because
If I just want a legal answer to this question, not a factual one, because this is a hypothetical. Can the board credit the unfair labor practice evidence put on by the employer?
well, hypothetically, I suppose the board could, but part of the
Okay,
problem here is
it's
we don't know what the board did here. And this brings us to another issue that was raised that was not addressed by the board.
Mr. Ellis, if I may, it seems to me, my understanding of your argument is that your client understood the ULP under consideration to be salary sharing.
Yes.
And putting together a salary sharing spreadsheet. And in defense, your client said, we didn't fire them because of the salary sharing. Look at this chat where they were saying all these disloyal other things that we didn't like. We want to fire them because of stuff in the chat. And then the rug was pulled out from your defense when the board then said the chat that you relied on as your defense was the ULP, when it seemed to me that you were relying on the chat as a defense to the spreadsheet. Now, the aspects of the chat that were inextricably intertwined with the spreadsheet and salary sharing, I think, are covered by the case law that says it's not in the complaint, but if it's closely connected to the subject matter of the complaint, which was salary sharing and spreadsheet, and it's been litigated, that would be okay. That's kind of what the ALJ did. But this working conditions, the workplace conditions thing kind of came out of the blue. And now they're relying on the chat talking about workplace conditions, and they don't even specify what workplace conditions they were talking about. And you didn't have an opportunity to address workplace conditions because you never knew that was an issue. When workplace conditions came into the picture at the NLRB stage, the hearing was over, the exceptions had been filed, all your arguments had been made, and then out of the blue, they're relying on workplace conditions, and you never had a chance to know what those were or what your arguments would have been against workplace conditions, ULPs. And I thought that was your argument.
Well, that is our argument, Your Honor. And you can't tell from the board's opinion what the workplace conditions were that the board found were being discussed in the chat that were protected. Is the board saying that it is a protected activity for developers to be talking about, we're all going to leave at the same time, we're going to recruit another developer to go with us, we're going to purge our computers, and we're sharing all of these discussions with a former employee who is now employed by a customer? is that a protected activity because it's a discussion of workplace conditions? We can't tell from the board's decision because they didn't provide any reasoning around that decision.
So for the two, Dragoon and Swift, who never mentioned purging computers,
Well,
there's never.
they didn't object either.
Okay. All right. So now you want to say, is it unprotected activity to not object to another employee's statement?
Mr. Dragoon was a team lead. If a developer is saying, we're going to purge our VIP computers.
That's not what he said. He said, it's pretty clear in context. He was saying, get rid of what we were saying about the spreadsheet because Mr. Bendel just got fired for that. But, and that's how it was stood. And that's why it was all deemed pretext by the ALJ. And so I want to get back to the point. Is it your position that employers can lawfully fire employees for discussing with each other their unhappiness at work, their desire to leave work? Hey, you want to come with me? Either I know a good employer or we could, they could bring someone with them for a lot of reasons, set up our own shop, or I got this great idea, this good company over here I heard is hiring. Is that permissible?
My client certainly thought it was. And
As a matter of law.
And as a matter of law, there's nothing that says it's not. And that's not what was charged in this case. In the absence.
Well, one thing that makes things an unfair labor practice is if you're not employers aren't consistent in their treatments. And there was testimony that there was a program manager who said, we don't object to people talking about leaving, investigating options, because we don't want someone here if they're unhappy. And so if you're inconsistent in how you apply something like that, then it would be.
I don't think there's any evidence that there was any inconsistency in how this was applied. If you're trying to roll out a restructuring of the development teams, it requires everybody to be on board. And now you find out that 3 of your developers are not on board. And in fact, I have a foot out the door, intend to leave, and are trying to take other people with them, and are discussing this with somebody who's employed by a customer, and are talking about purging computers. And I'm sorry, Your Honor, software developers talking about purging their employers' computers is unacceptable.
I think the purging computers point, there's kind of a factual finding by the ALJ that was pretextual, but the taking another employee with you, can an employer fire an employee for trying to, I guess, poach another employee, or is that protected?
I don't see why that's protected. There's certainly no case law that says that that's protected. And again, that's not what's
not protected. And if that is a working condition, that was the basis of this, I just think it's very unclear whether what the NLRB did was.
Well, that's exactly my point, Your Honor. It is very unclear. And the board also did not address the other issue, which we raised before the board, which is the act does not require an employer to allow employees unfettered use of the employee's IT resources to even to engage in protected activities, unless the
Can I
employee.
ask a separate question? So on this, just to stay back on this charging issue, our precedent requires a showing of prejudice. And what you said in your brief is, well, we would have put on other evidence, or I can't remember if you said would have called other witnesses, but there's no specificity at all as to what you would have either not done or done.
Well,
What is your best case for a finding of prejudice being based simply on statements that we would have done things differently without specifying substantively what story you would have put on?
I think to begin with, Your Honor, if the charge had been that it was that these 3 developers were unlawfully terminated because of their participation in this group chat, VIP would not have relied on the group chat as a defense to the charge. It would have put on an entirely different defense, and it would have zeroed in more on exactly, and frankly, there is evidence
What
on
evidence would you have had of their disloyalty, their desire to recruit someone to go with them, other than the chat?
We would have brought in the other employees that were parties to their earlier chats that were discovered after they were terminated. And this occurred
But you
weeks.
can't rely on stuff that you discover after they're terminated to prove the reason for termination.
We can
You have to rely
absolutely,
on what the people knew at the time they made the decision.
to show their motive and what these individuals, how truly disloyal they were.
If that's not evidence that the decision maker had at the time of the decision, you can't rely upon it. There's no after acquired evidence theory here.
No, well, it doesn't have to be after acquired evidence. If we're trying to prove that these individuals, we're trying to extrapolate now from what we do know, which is we can see in this
You
chat.
say, what did the decision maker know at the time the decision was made? And that was all from the chat,
And we knew that they were disloyal. And if
from the chat.
from the chat.
So, I'm really trying to understand for your prejudice showing here. If it seems to me the very thing that you want to rely on to demonstrate, that you would have relied on to demonstrate a different reason for their termination is the very chat that you put into evidence.
Well, it's not a different reason. It's the very reason that management discussed and the reason the VIP has advanced all along why these individuals were terminated, because they were disloyal, because they couldn't be
If you
trusted.
advanced it all along, you put your evidence on. I mean, that's your point, that this was our affirmative defense. It wasn't the spreadsheet.
But if
It was this disloyalty.
if we had known that the chat itself was going to be deemed a protected activity, and
You don't know
incidentally,
if it's going to be deemed to be, that would be.
and the the board specifically found that VIP monitoring and investigating this was not a violation in and of itself. So we found information, we relied on that information to fire these individuals. If we would have known that this whole chat was going to be considered the protected activity, we would have gone into a lot more evidence about exactly how disloyal these people were. And that,
Again, I think we're going to show prejudice. You have to show what evidence you would have put on for their termination that was before this decision maker at the time. So and we know the decision maker tells us exactly what he was relying on here. Right? People poisoning the well. And you're talking about the restructuring. So this was a particular point in time of sensitivity. All right. So you've got that here and you put the chat in. So it seems to me that it's not that you want to put on more evidence. You want to have a board finding about this legal question of whether what they said in the chat was protected or not.
well,
Is that right?
that's certainly something that the board ought to
Yeah, but that's a
decide.
very different evidence. That's a very different argument. Your brief and your argument in your brief was we would have put on different evidence. But it seems to me the basis for the decision for termination is right here, Mr. Simard's words. And that was from the evidence from the chat.
Well,
And so your argument seems to be in response to Judge Pan, not that we would have put on new evidence, but that the board needed to make a new legal finding about whether that was protected or not.
it's both, Your Honor. It's both, Your Honor. If we had known that this chat itself was going to be considered the protected activity, and as Judge Pan has pointed out, we don't know exactly what about that the board is saying was the workplace conditions that was the protected activity. We don't know that. But had we known that, we would have not relied solely on, we didn't fire them for creating and disseminating a salary spreadsheet because there's no evidence that these three actually did that. What we fired them for was their participation in this chat where they made these
I
comments.
agree with that. So that
I'm sorry,
I'm trying to understand.
why isn't it the case that you wouldn't, if you had known that the chat was potentially a ULP, you would have parsed the chat more? Because what I'm confused about is which parts of this chat are allowed and which parts are not allowed. And, you know, what are they relying on? It just seems to me that it is unclear. It's not just the chat, because there's stuff within the chat that is protected and stuff that's not. And if you had known that this was part of the inquiry as to what was a ULP, wouldn't you have parsed the chat and figured out what was allowed, what was not allowed, and maybe crafted your defense in response to that? And also, I believe what happened was when you saw this chat, you also pulled up performance evaluations of each of these employees. And might you have relied more on performance evaluations now that in combination with the parts of the chat that were not protected? It just seems to me that if it was never on your radar screen that parts of this chat were going to be part of the ULP, you just would have done your defense differently.
Absolutely, Your Honor. We would have had a completely different defense.
I don't understand this. I'm still not getting this. You don't get to just parse up the chat. The chat's going to be turned over to them. They're going to have it. It's a really bad strategy. Everyone knows to just pick your favorite pieces and put something in, knowing that the other stuff's going to come in from the other side. So this chat was coming in and it was in. And the performance evaluations were not anything that Mr. Simard relied on in making the firing decision. We have that testimony, right? And so I don't know why those would have been relevant. It seems to me your argument is not an evidentiary one. It is the one that Judge Pan was referencing, which is there's a lot of stuff going on in this chat.
Right. And
What was protected and what was not. And you want to point to the parts when Mr. Simard said that they're poisoning the well and destroying the happy culture at the workplace. And I take that the I'm unhappy, want to leave is the poisoning the well. There needed to be a legal ruling by the board.
two things.
Why are you fighting this?
Two things. Number one, Mr. Simard also testified that he was very disturbed when the statement by, I believe it was Mr. Swift in his performance review was read at the managers meeting where Mr. Swift said, I have no loyalty to VIP. In the context now of this chat, that was very concerning.
Was that right before this event or when was the date?
That was in his last performance review.
How long before this event?
I don't know, months. But it was something that hadn't come to Mr. Simard's attention until they were focusing on these chats. But this is exactly the problem. You know, VIP is looking at.
Do you want a legal ruling from the board as to what was protected or not protected?
I think at a minimum, we need that, Your Honor. At a minimum, we need that.
Because couldn't you have focused your defense on the parts of the chat that are not protected, like trying to poach another employee, combined with the performance review, lack of loyalty? I mean, it just seems like you could have crafted something if you had known that parts of the chat were going to be ULPs. You could have figured out which ones were not protected and tried to emphasize those more. I don't know. It just
we could have.
It's very unclear to me as a labor expert what parts of that chat reflect protected activity, what parts were not protected, and what's a working condition in the context of this chat.
And
I don't understand it.
And this is exactly the problem. And I'd like to leave the court with this. This is the problem that VIP was confronted with. We have employees who are engaged in unprotected activity that makes VIP feel a lack of confidence, a lack of trust in these developers with the access that they need to have to VIP's infrastructure. But these employees have also engaged in a protected activity of salary sharing, and VIP recognizes that. So what is VIP supposed to do? They did the only thing they could do. They fired these employees for the unprotected activity, and then they went to their workforce repeatedly and said, we do not have a policy against salary sharing. You are free to share salaries. That's not the problem here. The problem here with Mr. Bendel is the way he did it, publishing this unattributed spreadsheet.
I remember that from the record. I suspect that my colleagues do as well. Is there anything in the record about VIP firing people in the past for disloyalty or disparagement of management? And this is not a totally hostile question. It's just whatever. Answer it accurately. But
I think the testimony in the ALJ hearing was VIP had never seen anything like this before.
Oh, okay. And as I understand it, on page 29 to 30 of your brief, you go through at least 3 different strategic tactical things you would have done differently if this conduct had been charged before it was too late. Am I right about that?
That's correct, Your Honor. And
Can I now go to the totally different topic, Bendel? You say that he was fired not for the spreadsheet's inclusion of salaries, but he was fired because the spreadsheet was misleading and confusing. Right?
And a little bit more, Your Honor. It was the timing of the whole thing. Mr. Bendel had had his meeting with his supervisors the day before, where they talked to him about the restructuring and his role in the restructuring. And he had been given a free agent role because management was already concerned that he had a foot out the door and he might not be sticking around. He didn't respond well to that. He used a scatological term to refer to how those meetings went. They didn't go well. So he was already on thin ice. They didn't make any decision about what to do about that at that point, except go forward with the rollout of the restructuring and then decide based on his response to that, maybe we need to revisit Mr. Bendel. They have the meeting on the morning of the 16th to roll out the restructuring. Almost, immediately after this meeting, this spreadsheet appears and is brought to senior management by a supervisor who says one of his developers has come to him and says, what is this? He doesn't know what it is. The manager doesn't know what it is. They're wondering if it's a VIP initiative. Management goes into the system. They see that Mr. Bendel created this the day before. They can see that it's not clear. There's no attribution about where it's coming from. It's on a VIP active document on a VIP server. They don't know exactly how this has been shared, but they also can see that he has hard-coded it so that no matter what data gets put into the spreadsheet, is going to produce this result that says 100% of developers are underpaid. They say Bendel is trying to disrupt the restructuring because he doesn't like it. He doesn't like the role that he was in. We're going to take down this spreadsheet while we investigate it. And again, the board didn't find that taking down the spreadsheet was an unfair labor practice. And we're going to fire Mr. Bendel. And then we're going to go to our workforce and we're going to tell them, look, salary sharing is not the problem. You can share your salaries. We assume that's what you're doing. The problem was what Mr. Bendel did with this document. That's not okay. And again, we briefed this issue.
Just because of that one statement that they're all underpaid, because he didn't make that statement. It was somebody else who added that.
No, he did.
Trevor added that.
No, Mr. Bendel made that. At least, and the ALJ found that management reasonably believed that Mr. Bendel did that. That he's the one who had hard-coded it
Is that the only problem with the?
No, that's not the only problem with it. The biggest problem with it was the timing of it. It was on a VIP document.
Timing. So no one was allowed to discuss salaries during the rollout.
To put out a spreadsheet.
No, I'm asking the question. You just said timing.
Of course, people can discuss salaries. People can
Including during this rollout or restructuring.
Absolutely, people can discuss salaries.
So
That's not the problem.
Issue.
That's not the problem was all of a sudden, instead of focusing on the rollout, developers are looking at this spreadsheet. They don't know if it's a management initiative. They don't know what it is. They're confused about it, which is why it came to the attention of VIP management. And then they can see that it's got inaccurate information on it. It's clear that this is Bendel's.
What's the inaccurate information?
Some of the salaries were inaccurate, and the way that that Bendel had programmed it so that no matter what data was put in, it would produce this statement that 100% of developers are underpaid.
Was it programmed or someone just typed? People were just typing information in. So someone just typed information. I mean, you look at it, it's not mathematically changing. It's someone just typed in that statement.
Bendel hard-coded it, so no matter what data was put in, it would produce that same
Can
result.
you explain that a little bit more? I mean, there's a screenshot of the spreadsheet in the record, but it's a screenshot. And as you know, with spreadsheets, each cell may well have a formula that leads to what you see on the screen. You don't always see the formula. What was the hard-coded formula in the spreadsheet that caused it to always show that 100% of developers were underpaid?
I'm not a coder myself. I can't provide the technical explanation for that, but what I can tell you is there's undisputed evidence on the record that management went into this spreadsheet and they could see that Mr. Bendel is the one who had hard coded this. So no matter what data went in, it would produce the same result. That's what management saw.
I'm not, you lost me almost at the beginning, so you're not a coder yourself. I mean, I'm not a coder either. I can barely turn on my computer. I'm definitely not like Java coding some software program, but I know that with a spreadsheet, you can put in like cell 1 plus cell 2. And if that's the formula for cell 3, then if cell 1's 1 and cell 2 is 2, cell 3 is going to say 3.
And you can put in a formula, so no matter what goes in, 2 plus 5 is going to be 6.
Exactly. So
and that's
that was the formula.
I don't know what the formula was, but that was the conclusion of management, is that is effectively what Mr. Bendel had done. And by the way, there's other evidence too that contemporaneously with this coming on, there was another developer who was complaining that she was trying to put her salary in this spreadsheet and Bendel kept messing around with the formula. So this is what's going on while people are.
Did management know that before they fired Bendel?
They knew that. No, they found that out as part of the later investigation.
I'm gonna go back to this because it matters to me. I get that I hear you saying it shouldn't matter to me and it doesn't matter to you, but it matters to me. If the bottom of the spreadsheet had just had a cell that said, "Hey everybody, in my opinion, we're all underpaid," that I think would not be especially confusing or inaccurate, because it's an opinion. An opinion can't be inaccurate.
Agreed.
And it wouldn't be confusing. It's actually not at all a subtle point that person would be making. Okay, but if, on the other hand, that cell is something that a viewer of the spreadsheet thinks, okay, this is the product of a mathematical formula based on whether the salaries that are entered are high or low, then I think it's pretty confusing. They think that cell is could possibly say something other than 100% are underpaid. So you haven't given me anything to help me think that it's the second of those scenarios and not basically just a bumper sticker that says we're all underpaid. Can you give me anything?
I can tell you that management, and these are people who know all about, entering data in spreadsheets and how to make spreadsheets. Their conclusion was that what Bendel had done was the second scenario, was that he had created.
Comparing it to. You can't have a statement, you couldn't have a mathematical formula computing underpaid status unless you're comparing it to other salaries. Was there any input anywhere in this document that showed what other developers in other places are getting paid?
Well, that's part of the problem.
No. This is a yes or no question. Was there anything in this spreadsheet that would allow a computer to then make a computation, but always have this one number come out to compare these salaries?
No, Your Honor.
Absolutely not. So
there
it
was
was just typed in. It was a bumper sticker.
Well, but part of the.
You can't decide underpaid unless you have a comparison.
If I can answer your question, Your Honor, there was absolutely nothing in this spreadsheet that said underpaid as compared to what. You're absolutely right. But it also wasn't.
Nothing to compute.
But it also wasn't. This is Chris Bendel voicing my opinion that 100% of developers are underpaid. It had no attribution. It wasn't clear where this was coming from, what its purpose was, and developers now are entering their confidential salary information on this spreadsheet.
It seems to me that even if you had a colorable argument as to why what your client did was justified, that doesn't mean that there wasn't substantial evidence to support the ALJ's determination and credibility, which relied on credibility and evidence in the record, that that's not really what was going on here, that Bendel was dismissed because of the spreadsheet and all this other stuff that you're saying. The ALJ found it was pretextual or not really what happened. And there's substantial evidence to support that based on the timing of his firing, et cetera. So even if you do have a colorable argument here, that's not the analysis before us. We just have to determine if there's substantial evidence for the ALJ's contrary finding that that's really not what happened. that everything you're saying is pretextual. And what really happened was you were unhappy that he created the spreadsheet, disseminated the spreadsheet, you fired him for it. And all this other stuff is actually not the real reason.
Thank you, Your Honor. And this is where you have, with respect to Mr. Bendel, this is where you have to look at what the ALJ actually found and what the board actually found. VIP has never disputed that they fired Mr. Bendel because he put up this spreadsheet. That's exactly what he did that led to his termination. What they have disputed all along is that the termination was motivated by any kind of a retaliatory animus towards salary sharing. And this is the important distinction. And I think it's a distinction that the board made when they said we are not adopting the ALJ's finding that merely taking down the spreadsheet is evidence of retaliatory animus. So they're not relying on that. So where is the evidence that VIP was motivated by retaliatory animus towards?
Does it have to be retaliatory animus for those reasons? I mean, just firing somebody for doing a salary sharing spreadsheet, that's protected conduct. The spreadsheet was salary sharing.
The spreadsheet was a spreadsheet. Salary sharing is salary sharing. VIP could
The
legitimately.
spreadsheet was a form of salary sharing. Everybody put your salaries in the spreadsheet.
Right.
They're sharing their salaries.
And part of the problem with
And
that,
firing somebody for that spreadsheet is a ULP. And I guess under right line, you could say we would have fired him anyway for these other reasons, but the ALJ said those other reasons are pretextual and we don't credit it.
well, this is why we need to get to what the other reasons were and what.
Well, I think that's a different. So the chat is really not about Bendel. It's about the trio.
Right.
And that's different.
That's different.
But
But with.
Bendel, I think, is very straightforward. It's ALJ says you fired this guy because of salary sharing. And you admit that it was salary sharing. So under right line step 2, you have to say we would have fired him even if he hadn't done the salary sharing. And the record's very thin on why you would have done that, because you had not done so even after he had these problematic interactions with his supervisors. You hadn't fired him.
If this spreadsheet had nothing to do with salary sharing, but had been, sports betting or something else that's not protected, it would have been the same thing because he was disrupting the restructuring with this
No, I understand,
spreadsheet.
but the ALJ discredited you. That's what you say. But the ALJ said no, it was because it was salary sharing.
But the ALJ relied on taking down the spreadsheet, which the board said is not evidence of retaliatory animus. The only other, the board didn't say what other evidence of retaliatory animus the board found. What the ALJ said is shifting explanations.
I thought it was your burden under right line step 2 to say that you would have fired him anyway, even though you did fire him in part because of salary sharing. I thought right line says you're supposed to now prove, despite that, we were going to fire him anyway. And the ALJ said, no, you weren't. And it's supported by substantial.
Yes, but to make a prima facie case, the board initially has to prove that it was motivated by
I
retaliatory
thought you
animus.
conceded that. Well, you conceded that it was because of the spreadsheet, which
But
is
not
salary
because,
sharing.
but not because of salary sharing. And this is
I think, so do you have more on this? No, I think
I have one.
we have one more
Sorry.
question over here.
You said a few minutes ago that the management at the company understood the 100% underpaid cell to be the product of a coded formula. Where can I find in the record that that's what management?
It's cited, I don't have that cite in front of me, but it certainly is cited in our briefs in the statement of facts. It would be in
Well, I'll just
Respondents Exhibit.
I'll save you time, or you save me the time. Can you tell me?
Respondents Exhibit 40.
Can you tell me on rebuttal?
On rebuttal, you can bring that in.
On rebuttal, can you just tell me the JA page?
I'll do that. I'll do that. Thank you. Your
Thank
Honor.
you very much.
Thank you.
Mr. Sauter?
Hello, Your Honors. May it please the court, Rick Soter for the NLRB. So this is about as straightforward and as classic board case as you're likely to encounter. This case involves 4 employees.
I saw that in your brief. I mean, you've already heard 2 judges who don't.
Did I say that?
You
Sorry.
said in your brief, this is like the most straightforward
Oh,
NLRB case ever. We could decide this in our sleep.
Okay.
But we've already heard 2 of us express some pretty serious skepticism.
okay.
Okay.
Do you
Would
want
you
to
like me
address
to
the
continue?
charging issue?
Sure.
to start
Well,
there?
so
Unless my colleagues prefer something different.
No,
well, maybe the simplest way to do it is there was the issue, as you noted, of Bendel and the issue of the trio. I didn't hear the
As
court.
to the trio. I think.
I didn't-
Can we talk
Do you want
about the
about
chat?
the chat?
Can you tell us
Yeah.
in that chat, what was protected, what was not, and what was a working condition?
So, Your Honor, the board found that what the employees were fired for, what the trio was fired for, was discussing salaries, working conditions, and discussing Bendel's firing. In that,
What
in that chat-
What are the working conditions in that chat?
in that chat, I mean, frankly, I think it's the salaries issue. I think the board probably repeated itself in that
I have
sense. I
the
think
same
it's a
question
salary
Judge Payne
issue.
has. Can you first get the JA, pull up the chat and say what exactly was protected and what exactly was not protected?
Okay.
Wait, unless you have a photographic memory, I think you're going to need the JA for this.
No, I can actually. There are different parts of the chat. Like, for example, you talking about quitting, talking about job hunting, that's not protected.
I want to follow you along word for word. What
Okay.
page of the JA am I supposed to be looking for?
Okay, so this is in the SJA. Oh, no, I'm sorry. My bad. I have it in SJA, but I have the J numbers.
Aren't you got
So-
1111 spreadsheet?
Right,
Is that
right.
where you guys are starting?
I had 1249,
Oh, okay.
maybe 1111 might be a better one.
No, it might not be. Okay. What page do you want to start on?
So the, as I have it, it starts on 11:58, the chat, and it continues through 12:01.
So you're starting at 11:58?
Yes,
Okay, so the chat starts long before that.
the chat starts, it's Exhibit 14. It starts with Weiss Caleb, not lead of WMS.
What's all the stuff before it that also looks like chat?
Is that not a relevant chat? Is that a different chat?
Let me look.
Looks like there's a different chat. That's Exhibit 10 that starts at 11:32.
Right, so 11:56, 57, that's a different chat. That's exhibit. I'm not sure if it's exhibit. I think it may be exhibit 12, actually.
And then even the one that you said starts at 11:58, I could be wrong, but it looks like that chat in the 2 line includes Bendel and a lot of Bendel statements in the chat. But I thought the chat that they were fired for was the chat that happened after Bendel was.
No, Your Honor. Bendel was fired in the course of the chat. The chat that they were fired about,
Bendel is literally chatting with. them.
Bendel was chatting with
He finds out he's fired.
Yeah, Bendel, well, he disappears. The others find out. At some point in that chat, one of them says, "Oh my God, Bendel's account has been locked out. What's happening?" The others go, "What the hell?"
Okay.
And then later on, they say, "It's official, Bendel's been fired." And that's where you have the purge your computers comment. So all of this happens. What happens is the spreadsheet, Bendel and Noble have their conversation about the spreadsheet on one day. I think it's the 16th.
And what page is the purger? Because again, I originally had 1249. That includes
The purge-
your computers, but there may be a better chat that you're describing, a more relevant chat. They also
the
say purge.
Sorry. The purge your computers is at 1197.
It's also at 12:49.
Yeah, that's an affidavit from somebody from the beginning.
Okay. So this is this thing on 1197. By this point, Bendel is gone from the chat.
Yeah, if you read actually the page before at the very top, Dragoon says he was actually fired.
Okay. And then this is the chat that these other three were fired for.
Yes.
Okay. And then going to Judge Pan's question, and thanks for helping me get on the right page.
Sure.
I may have been looking at a copy of the page. What's the protected activity? What's the unprotected activity?
Right.
I'm sorry,
Just-
which page are we on?
Oh, well, just one point to start. I've heard Mr. Ellis and the court say the chat was protected. No, there are statements in the chat that are unprotected.
That's what we're asking.
But
We never said the whole thing was protected. We're saying
Mr. Ellis certainly said that if we had known that
Question
the
to
chat
you
was the ULP.
Our question to you is what parts of the chat are protected and which parts of the chat are not?
The parts about salary sharing, about where they discuss salaries, where they discuss the spreadsheets, and where they discuss Bendel's termination. That's what the board found. They were fired for discussing their salaries, the
So
spreadsheet, and
discussing
Bendel's
somebody else's
termination.
termination is
sorry?
protected conduct? Is generally discussing somebody else's termination protected conduct?
No, but discussing somebody's termination for engaging in protected conduct certainly is. And conduct that you have engaged in yourself because you participate in the creation or dissemination of that spreadsheet.
Mhm.
Okay, so going to page 1196, the third line from the bottom says Jesus F-ing blank. Is that protected activity? Can you fire someone for saying that?
You certainly can, Your Honor.
Okay.
But
Then-
when it's intrinsically linked and part of an entire discussion of salaries and of a guy being fired for protected conduct. This is what VIP tries to do. They basically try to sort of gerrymander in and out the sentences that may not be that are not protected, like saying you're
If
job
we could
hunting,
just
that's
stick
not
with-
protected.
If we could just stick with our questions.
But that's
So
what.
is the chat portion that says, let's take Fung with us, that's a really good programmer, let's all quit and let's take him with, is that protected?
No, on its own, it's not. But in the context, when they are talking about Fung doesn't get paid enough, he should come with us, and all of that, then you have, the board recognizes, and I think this court.
What are working conditions? Like in this discussion of all these different things, what's a working condition within this chat?
I think, like I said, the salaries and the fact that one of their colleagues just got fired for engaging in protected activity, which they know is illegal, and that they are now afraid that they might get fired for the same reason.
But you're just inferring that. I mean, I guess the issue is when the NLRB issues its opinion, all of a sudden it's injected working conditions into the discussion where I think the position of your friend is, we never knew working conditions was a ULP we had to contend with. And you're saying, I assume that the working conditions are the same ones as the salary, but how do we know that? Because there's pretty extensive chat now that I'm looking at it. It's very many pages. And there are things, I don't know if it's the same chat or other one, there are things that are like F management, like all these different things. And I just don't know what these people, what the NLRB held was appropriate or not. If they, once you inject working conditions, that there's never been any discussion of working conditions in the entire record, I don't understand where we are.
When the board adopts the LJ's finding and says they're talking about salary, salary sharing, working
The
conditions.
ALJ didn't rely on working conditions.
Well, working conditions is whatever the ALJ discussed, right? Whatever's in there. And
So anything that ALJ
No.
discusses in any NLRB case is a
No.
working condition? Because
Is-
the ALJ didn't rely on working conditions.
The ALJ relied on people complaining about being underpaid, which is undeniably a working condition, right? And
It is a working condition, but
Right.
I don't know if there are other working conditions in the chat that could form the basis of the NLRB's finding, because
Well-
there's never been any discussion of working conditions, so I just don't know where that comes from or what it's referring to.
the only working condition that the ALJ discusses is the fact that they're underpaid and the fact that they're upset and they feel like they're going to get fired themselves for engaging in protected conduct. If the board says working conditions, it says that based on things that the ALJ found, it's not inventing a new working condition.
So the NLRB said, the board said that they were chatting about, I'm just paraphrasing here. I think it was salaries and then working conditions and Bendel's firing.
Right,
And that was the protected activity.
right.
But if VIP never knew that working conditions was a part of the analysis, how is that not arbitrary and capricious to inject it after the record has closed, they've already filed their exceptions, and all of a sudden you're relying on something they never had a chance to address?
But the only working conditions discussed by the ALJ are the fact that they're unhappy with their salaries. The board didn't say we're relying on some other
Well,
statements.
shouldn't the board have to spell out what working conditions they're relying on? Because the ALJ didn't rely on them, and there's never been any discussion of working conditions before in this record.
I mean, working conditions is an extremely wide term, Your Honor.
Exactly.
And I don't think.
Exactly.
And I think when the board says working conditions, it relies on what's in the ALJ's opinion that relates to working conditions, namely the fact they are underpaid. So
I guess the thing that troubles me about this record is it seems to me that the general counsel said the ULP that we are going to be talking about is salary sharing and the creation of a spreadsheet and the dissemination of a spreadsheet. The ALJ did take that a little bit further, but I think probably permissibly when it said chats about the spreadsheet. That's inextricably linked. It's been litigated. That's a ULP. And I think the position of VIP is you told us it was about the spreadsheet. So our defense was, look at this chat, look at all these things they were saying. And all of a sudden you pull the rug out from under us by saying our defense, which was in this chat, was the ULP. And then you don't even tell us what it was in this chat that you're actually relying on. Because there are parts of it that could be, as the ALJ said, inextricably intertwined, but other parts that are not. And it would be unfair for you to rely on the things that are not inextricably intertwined. And we didn't have any opportunity, if you did rely on the things that are not intertwined, to address them. But we don't know what you relied on because all you said was working conditions. I mean, that sounds pretty compelling to me.
Well, okay. I think well, I'll get back to your question, but I just want to make one point. Even if, let's say, the workplace conditions was, a problem, I would argue that it's still harmless error because the boards still found, based on their chats about their salaries and being underpaid and Bendel's termination, that those were the unfair, that was the protected conduct within the spreadsheet. So even if,
So we were discussing that.
VIP had the chance to defend against that.
But could they have sort of rejiggered or changed the way they defended this case if they had known that working conditions were a part of it? Because then they might have tried to ascertain within the chat what's protected, what's not, what's a working condition, and then they could have shifted their defense to address the board's or the ALJ's concerns. If the concern was about working conditions, didn't they have a right to know what the concern was and what the working conditions were so they could address them or change their defense strategy? Because then they could parse this chat and say, which ones are the ones you're concerned about? We're actually relying, it seems that nobody's disputing that it would be a firing offense that's not protected to try to poach another developer and have them leave the company with you. They could have said, we were really the most concerned about that,
Right.
and combined with the performance review. Like they just could have reemphasized or changed, the way they approached this if they had known that your concern was working conditions. And then they would have tried to figure out what the working conditions were that you were concerned about. And they could have adjusted their defense accordingly.
Every point you just made, Your Honor, is a point that they made in their argument and is evidence that they put forth. So I think that goes back
But
to
but
the,
if the ALJ had credited them, if they had changed their defense a bit and said, we're the most concerned about the poaching of other developers, like this is something that is really not acceptable to us. You know, we can't have people within our organization telling other people in our organization to quit. That was the most troubling thing to us. And if the ALJ credited that, that would be a permissible firing. It would not be a ULP.
actually, Your Honor, this is where I would push back. If you make comments that are within a discussion, a protected discussion, and you make comments that, fall out of there, your discussion does not lose its protection. The whole thing.
Oh, I thought you would agree that's not protected conduct.
No,
to
I
take
agree
somebody-
on its in isolation. If VIP comes across a chat and it's these guys saying, hey, we're going to quit and we're going to get this guy to quit with us. Let's all quit together. Unprotected, no doubt. If they say, we're not getting paid enough, this is ridiculous. Hey, he's not getting paid either. We should all leave together. And by the way, we're circulating the spreadsheet, all of that. Then it's inextricably linked and you can't just separate one from the other.
So these three employees could have said anything.
No. There are things that you can say that are so egregious that they will cause you to lose the protections of the act.
What's an example?
Off the top of my head, I couldn't tell you. It's under.
Management?
No.
No?
It's under the board's Atlantic Steel analysis. Things that are too serious that they will cause you to lose. Like, for example, this isn't saying something, but if you start if you're talking to your employer and you're arguing back and forth and all of a sudden you hit the employer, you lose the protection of the act. Doesn't matter what you said before.
What if you use hate speech toward the employer?
Or you use hate speech toward the employer.
What if you say toward the employers, F these pieces of blank so hard?
If you say it to their face, maybe, but not when you're talking amongst yourselves. That's all.
Really, I'm just curious about
Yeah.
this because if I'm an employer
Yeah.
and I think that everything's going fine with this employee,
Mhm.
and then I find out that they're saying F
Which is a direct.
this
by the way.
manager,
I know.
yeah, so hard, and I'm disturbed by this and I want to fire them, I can't.
Yes, you can, if that's all they said. But if it's in the middle of a discussion, what the board recognizes, and I think this court knows, is when you're talking about protected conduct, that doesn't mean that you don't inject things. Conversation doesn't work like that. You don't just say, okay, now we're just talking about protected conduct and we're not going to say anything else. And now we're done. Now I'm going to say F this employer so hard.
Can you fire someone for disloyalty?
Yes, but not if you associate disloyalty complaining about your salaries.
Right. But so if someone is advocating for, let's say they've got a sign that says unionize, unionize, unionize.
Yeah.
Independent of whether or not they are in favor of a union, you come to the conclusion they are a disloyal employee. Not disloyal because they want to unionize, but disloyal because they say things like F these pieces of F so hard. I don't see how you get to a get out of jail free card for saying extremely disloyal and vile things about your employer, just because a minute before you were saying unionize, or pay us more, pay us more.
That's I don't know how the board would rule in that situation because you're talking about one act where on one hand, this guy is doing this, and then maybe the next day he says, fuck these people so hard, excuse me. In this case, it's
thought
all
your answer
intertwined.
would
It's all
be-
part of the same ebb and flow of a conversation.
There's a lot of case
Excuse me.
law. There's a lot of case law out
Mhm.
there that says the board doesn't enforce Emily Post rules. There can be a lot of unpleasant language in workplaces. A lot has been tolerated. Picket lines, workplaces, break rooms. And so it's a very, very nuanced analysis before someone can get fired for using obscene language. It's really very nuanced and context specific. And there is a lot of precedent on that. So we can't just sort of pick up a transcript and say, oh, curse word, my ears hurt. you can be fired.
I wish
Take it,
I
that's your point?
was as articulate as you are, Judge. But
Okay,
yes,
so I agree
that is
with
my point.
That both Judge Millett is very eloquent and also that what Judge Millett suggested is correct, that when you are engaging in protected speech, you can use four-letter words, but that doesn't answer the question of whether this is itself protected speech or if this is a sign of disloyalty separate from wanting higher salaries.
When you are in the midst of protected activity and you interject other things like that, those become protected by association. You can't just
But
carve them out.
Is this a
Why are they
finding
saying
by
F
the
these people? So
ALJ?
why are they
Don't
saying?
talk over me.
Sorry,
Is this just a finding by the ALJ whether or not it's protected or not, depending on
Sorry.
the context? Is it just for the ALJ to make a finding as to whether or not it's protected or not, depending on the context?
well, I mean,
We're debating it in a vacuum here.
Right.
It's context specific. Sometimes it's protected, sometimes it's not, depending on the context. Isn't it for the ALJ to make a finding as to whether or not this is protected or not based on the context?
no, Your Honor. I mean, yes, there's LJ can
Right.
certainly make
So
the
my point
finding.
my point is, let's take Fung with us. We're all going to quit. Let's take Fung with us. Isn't it up to the ALJ to determine whether or not that's protected or not based on the context?
I think if it would be nice, I'll agree, it would be nice if the LJ had done so.
That's not what I'm
But-
saying,
but
whether
the
it's nice
law-
or not. What I'm saying is if they had had an opportunity to know what the concerns were within the chat, they could have homed in on, for example, let's take Fung with us and said, that's not protected and that's why we fired them. And then the ALJ could then decide that was protected or that wasn't protected or whatever, but that none of that happened because they didn't have the opportunity to know what was it within this chat that was allegedly a ULP or not, because that wasn't the focus of the complaint or even the ALJ's finding, which extended the complaint a little bit, probably permissibly, but then the NLRB went even further in an area that they didn't have a chance to address, which is working conditions.
Even if that was true and the LJ should have made that finding, ultimately, it is harmless error because as
But I guess my
Judge
point
Millett
is,
said.
how is it harmless if the ALJ didn't have a chance to address the argument, for example, that this is the thing that we relied on? Let's take Fung with us. ALJ, it's not harmless if the ALJ never was presented the argument because they didn't know that they were going to have to parse the chat like that.
It is harmless, Your Honor, because under board law, when you interject things like that within the context of protected conduct, you do not lose the protections of the act. You remain
I thought we just
protected.
agreed that the ALJ would have to decide what is protected and what is not, depending on the context.
Well, no, I'm sorry, that's not what I meant. What I meant is that, well, the harmless error in this case would be, as you're saying, the LJ didn't have an occasion to pass on it. Therefore, that's what they're complaining about. The harmless error intervenes because even if the LJ had passed on it under board law, it is undeniable and well established that you can say, F these pieces of S so hard,
No,
or
I'm
that kind of
focusing on
stuff
let's
in the
take Fung with us.
context, same.
I'm sorry, counsel.
Same.
You got up, I said, is that protected or not? And you said that is not protected.
In a
You
vacuum,
can't
yeah.
say, let's take Fung with us. Let's have Fung quit. I thought that's where we started. And now you're saying as a matter of law, that would be protected.
What I said, Your Honor, is that in a vacuum, making those comments, if they had found a chat that said just that,
Question to you was
that is
not
not
in a vacuum.
protected.
When I asked you this earlier in this argument about this case, I asked you, is that statement protected or not? And you said it is not.
In
And
this,
now you're saying it most definitely is.
in this case, the statement is protected by association because it occurs within the context
I
of
understand
protected
that. I'm just saying
conduct.
you've changed your position in the time that you've been standing here.
I do apologize, Your Honor. I do remember saying in a vacuum, maybe we misunderstood each other. I sincerely apologize. But I don't believe I've changed my position. It's certainly our position in the brief is that even if statements like that on their own are unprotected, when they are made in the midst of protected conduct, they acquire, or certainly they do not cause the employees to lose the protections of the act. And I apologize if I said anything differently.
In the context, imagine there's a union election. There's two competing planks. There are the incumbents, and then there are kind of challengers who say the union is doing a terrible job.
Mhm.
And they're in a break room, the employees are, and one plank is arguing that the incumbents are doing a bad job, and the incumbents are saying, no, we're doing a great job. And in the midst of that kind of hustle bustle and debate about the election, one of them says, some people here are not paying their bills. And as it happens, someone on the other side husband recently passed away, and they'd been forced to raise money for the funeral expenses. And then that same person who said that nasty thing also said, some people need to focus on their kids rather than the union. And a few days later, the incumbent person's son had narrowly survived a stabbing. These things are right in the middle of the election speech, back and forth, back and forth. This is from a case.
I know that case. I argued it in front of you.
Okay, then why was it
And I was
unprotected speech? Why was it unprotected speech there? But you're saying, in the context of this chat, they could have said basically anything.
In that case, Your Honor, if you recall, the person who made those statements, what the board found was that he started by talking about electioneering, and then he veered off onto something that had absolutely nothing to do, and then got into a back and forth specifically with this person where he said those things. That's where
talking about Bendel, they're talking about Bendel, and Bendel shouldn't have been fired. And then they veer off into, hey, let's go poach one of this company's employees when we leave. And also let's poach one of the employees' customers.
No.
Right?
No,
that wasn't the same thing?
No, they never said poach the employee's customer. They talked about calling up a former colleague of theirs who works now for a customer of VIP and telling him about what happened. There was no poaching of customers or anything like
That
that.
still seems off, a bit disloyal, basically sabotaged the company's relationship with an employee, with a customer. But I think if
I can certainly,
I have your answer to the McClam thing, but it seems like the argument that the board made there is not consistent with the argument the board made here.
I'm sorry. In McClam, the argument in McClam is not
Not consistent with the argument here. And
with this one here.
And I think, imagine that someone said, those managers should pay us more.
Mhm.
That's protected.
Right.
Imagine they said, those insert racial epithet should pay us more. And then the employer fired them for being racist. I think that's a fair firing, right?
Right. But if they say those MFing employers should pay us more, that is protected.
If they say, I'm sorry, we're underpaid. This is crazy what's going on. Bendel fired. My friend Joe over here, he's really underpaid too. Can you believe how underpaid he is? Wow. And they go, wow. Well, if we get out of here and get other jobs, let's bring him with us.
Yeah, protected by association. It's all about the spark about this. The reason they're talking about this is that they're frustrated with their pay. The reason they're saying F these MFers so hard is because they just fired a colleague for engaging in protected conduct. The reason they're saying, I don't care about these people anymore is because they're complaining about their income and they feel mistreated.
At some point, it becomes a little attenuated, though, because the original ULP is salary sharing, disseminating a spreadsheet. And then it kind of leads into we're all underpaid, which I can kind of see. But then it leads into and let's take other people with us if we quit. At some point, it's a little attenuated from the original ULP.
I can understand how, yes, at some point there's going to be a line, but if it occurs within the same, this is the main point here.
It was fairly litigated, right? There's actually a legal standard for that. Like that if it's inextricably intertwined and fairly litigated.
Right.
But
well, no, I
if
closely
nobody knew
connected
that poaching another employee was part of this. Like, I don't see why you can rely on that if you didn't say so. And I don't know whether you relied on it or not, because you didn't say so.
What the board relied on, and it said so, is the fact that they were complaining about their salaries and the working conditions.
Exactly.
And
Working conditions. What does that entail?
poaching an employee is not a working condition. I don't think we can, I think we can all agree on that. It's not.
Oh,
a
so
working condition.
it would have been fair to fire them for wanting to poach Fung?
All right, what does poach mean?
I mean, that was, I'm sorry, you're right. Poaching, we got sidetracked with the poaching. It wasn't poaching. It was talking about leaving with another employee. Poaching would be
Having a
taking
place
it.
for another employee.
Right,
If we
right.
get out, let's have a.
If we get out, let's take him with us.
Yeah.
That's what they were
Kind of
saying.
interfering with the
Right.
relationship between another employee and management, basically.
Right, right.
So if that's not one of the things, if they had said to the ALJ, that's why we fired him, that would have been lawful then.
No, Your Honor, if they had said that in a vacuum, yes. But if they said that,
In the context of this case,
In the context
where
of
the
this case.
ULPs that are under consideration do
Mhm.
not involve interfering with another employee's relationship with management, could they say that's actually, it wasn't the ULP that you're saying, it wasn't a ULP because we were actually concerned about this, the interference of our relationship with another employee. Would that be a valid defense if the only ULPs that are under consideration are spreadsheet creation?
perhaps if they had evidence that they separately from all this were actively trying to talk to this guy and leave with him, but just a statement thrown out in the midst of a complaint, in the midst of protected conduct, no, that it remains protected. I mean, it again, it's not protected in and of itself. It becomes protected by association.
So I guess my point is just that they might have had a different defense. Like if they had known that you were going to go in the direction of working conditions, they would have wanted to know which working conditions are you talking about? Does it include this other employee? And then they could have made an argument. We weren't focused on the ones you're concerned about. We were focused on these ones, and it would have been lawful for us to fire these people based on this other thing. But none of this was litigated. None of this was considered because they had no idea that working conditions were a thing in this case.
Right. And then that's where I come in and say, this is harmless error, because even if that was true, I would still be coming here and saying under established board law, when you just throw stuff out like that in the midst of a conversation that may not be protected in and of itself in a vacuum, it is inextricably linked.
You could know whether it's harmless or not, because you don't know what their different defense would have been if they had known that working conditions were a thing. You're basically saying there's no scenario in which they could have come up with anything that possibly could have made any difference, but you don't know what they would have done differently. I'm just giving you an example of something they
Right.
might have done that seems plausible to me, but there might be lots of things I don't even know about. But you're saying no matter what it was, it would have been harmless.
Well-
And I don't know how you can know that.
Well, they would also have to show us and to actually put forth something that they would have provided, you know, to support that they would have, they would have had to provide evidence or put forth evidence that they would have provided that is somehow different than what they already put in.
It
Like,
doesn't have to be different, does it? It just has to, they could have changed the litigation strategy. It's the same chat that's in evidence, but they could have emphasized something different within it. They could have said something in the chat combined with the performance review that was in evidence that they didn't emphasize. I don't know. I'm just saying they could have had a different strategy.
I mean, that I believe that's how I thought that was their strategy. They talked about Noble's performance review. They talked about, they brought all of those things in.
I think we're talking in
Right.
circles at this point.
Yeah.
Do you have any more questions? No. Okay.
None?
Thank you very much, counsel.
Oh, may I just, on the hard-coded, there is an answer to your question, Your Honor. The problem is it's a little awkward. The spreadsheet was introduced into evidence, the actual Excel spreadsheet. It was not admitted into the record. The court reporter included it inadvertently within the rest of the evidence, and it is actually part of the record that we have in the board's files. I don't want to say any more since it's not part of the formal record, but there is an answer to your question. I'm sorry.
That leaves some more questions than answers. I mean, how is the spreadsheet? The spreadsheet is Exhibit A for the unfair legal practice with regard to Bendel.
Right.
How could that not have been admitted into evidence?
They omitted to admit it. They introduced it and they didn't ask to admit it.
The company
company
asked to admit it into evidence.
Yeah, they introduced it. They questioned him about it. And then afterwards
the ALJ stage, the burden would be on the general counsel to prove the case, right? Wouldn't they need the spreadsheet as part of the evidence to prove the case?
The general counsel relied on photographs, screenshots that you have seen that are part of the record for
You're just
that
talking about
case.
the original was not admitted, but screenshots. were
Right.
admitted.
The screenshots were admitted. The original was introduced but not admitted.
Okay. Thank you for that clarification.
Yeah, sorry, I can't help you. Like I said, the answer exists. Because of that, I can't say it. Thank you. Yeah, the truth is out there. Thank you very much. We ask that you respectfully, that's the court enforce the court order in full. Thank you.
Thank you. Thank you. Mr. Ellis, I think, did you ask for 2 minutes? Is that right?
Yes, thank you, Your Honor. Judge Walker, to your question, the citations in the record to the evidence of how management looked at the spreadsheet and what they concluded about what Bendel had done to hard code it. I can give you the citations to that. That's the joint appendix at 1246, 841, 842, 1067, and 1053.
Thank you.
The discussions of leaving and taking Fung with us occurred before they found out that Bendel had been fired. It had nothing to do with Bendel being fired. And the discussions that were taking place in the chat at that time weren't just about salary. It was just they didn't like the restructuring for lots of reasons that they were talking about. They thought management didn't know what they were doing with the restructuring, and they objected to the restructuring, and that's why they were leaving. It wasn't just salary. So the argument that's being made here by the board's appellate counsel, even though the board didn't make this argument, is effectively they can say whatever they want, but as long as at some point in that chat they mention salary sharing, everything automatically becomes protected.
I don't
And
think that's his position. He said that you then have to switch to the Atlantic Steel analysis to decide something. So let's be fair to what he said.
But the implication, especially because we don't know from the board's decision what are the workplace conditions that the board found to be protected. Is it the board's view that the discussion about recruiting Fung and taking him with us is a discussion of workplace conditions? We simply don't know.
All right. We don't have any further questions. I think we've definitely got your argument.
Thank you, Your Honor.
Thank you, both counsel. The case is submitted.
They could have used that.
Case number 24-5193. Narragansett Indian Tribe, acting bind for the Narragansett Indian Tribal Historic Preservation Office, appellant, Mr. Sean McMaster, Administrator, Federal Highway Administration, et al. Ms. Walker for the appellant, Mr. Georgie for the appellates.
Good morning. Ms. Walker?
Great. May it please the court. This case, this is the application of the National Historic Preservation Act through what is referred to as the Section 106 process to protect tribal historic properties from harms caused by federal undertakings. In this case, it was an expansion of a highway bridge in Providence, Rhode Island, over a very significant historic property of the appellant, the Narragansett Indian Tribe. I'm going to skip some of the background because you've been here a long time.
That reminds me of one question from the record. The land is not tribal land, right?
No, it's not in trust. It was very significant tribal property, historic property, just some history, because when you study Indian law, you read a lot of history. That land in 1639 was a gift of the Narragansett tribe to Roger Williams, who established Providence Settlement. Roger Williams was very friendly to the tribe. The state leaders today are not, just different time. The tribe's position is the lower court erred in finding that tribes have no role under the National Historic Preservation Act, Section 106 process in the mitigation of adverse effects on significant tribal historic properties off reservation lands or lands not held in trust. I wish I could describe the 106 process as simple. It's not. It takes expertise and some understanding of the development of the tribal program under the National Historic Preservation Act to have the lights come on, so to speak, and see the distinction in the tribe's roles in different aspects of the process of determining the impact on federal undertakings on historic sites. To break it down, first on tribal trust lands, the tribe's Historic Preservation Office.
You're jumping a little to the merits, and could you start with the issue preclusion question?
That this was already litigated, that argument. Yeah. On appeal, what happened below was the court dismissed the claims against the government under the first programmatic agreement on the grounds that the government, the federal government, couldn't carry out the execution of that agreement because the state interfered. What's on appeal here is not subject to issue preclusion because it's about on the initiation of a new 106 process should the tribe have been excluded.
This appeal is about the second programmatic.
Exactly.
And the decision below said there was standing for the second.
Exactly.
But there was a suit before that where the district court said there's not standing for the second programmatic agreement.
Yeah. Yes.
Right?
Mhm.
So why does that decision not preclude?
Oh, no, the decision before that said not standing as to the first programmatic agreement, not the second.
The first suit didn't have anything to do with the second programmatic agreement.
Well, it does in the sense that they terminated the first programmatic agreement, initiated the second, but the state didn't interfere with the second because the state had been dismissed. And state had been dismissed because there were mitigation.
I guess what I'll say is when your friend from the U.S. Attorney's Office is there, I'm going to ask him to look at the complaint in the first case and point to where the complaint raised issues related to the second programmatic agreement. And if you can do that, I'm going to ask you why you still think that first case didn't have anything to do with the second programmatic.
Well, the first case involved mitigation properties that the state had control over as part of the mitigation of the project. And all parties, the state of Rhode Island Department of Transportation, the federal highways, and the tribe signed off that those properties that the state controlled would be mitigation measures, right? And then those properties weren't. And so the second agreement didn't involve those properties. And so the second agreement was about between federal highways and the tribe.
And I'm happy to be corrected. I thought that part of the government's argument was that your first suit said the second programmatic agreement was arbitrary and capricious. And this district court said you don't have standing to raise that.
No.
That could be totally off.
Yeah.
He'll tell me if he thinks I am, and you can respond to him.
I thought the nature of the discrepancy was that in the first case, it was about the second programmatic agreement, but there was no standing as to substantive injuries, harm to particular land, or the loss of benefits of the land transfers. But the court explicitly carved out and said, I'm not talking about procedural claims. And this current case is about procedural injury, failure to consult.
Exactly.
And that's the difference between the two.
Yeah, well, we argued in the, when he gave us, he dismissed without prejudice and allowed us to re-argue the standing part. We argued procedural injury, so you're correct.
So that's why it's not precluded by the first ruling.
You
This
did
is
not-
addressing a different thing.
You didn't
Yeah.
argue, you did not argue procedural standing in the first one.
No,
Okay, well, if he can show me where he thinks you did, then you can,
No.
you can respond.
yeah, and
Claim
this,
preclusion even apply to a case that's dismissed without prejudice?
we don't think it does.
Is a dismissal without prejudice and adjudication on the merits?
No, they're allowing
So
us,
Then it
no.
can't apply.
Yeah.
Hmm.
Hope that answers your question.
Well, I'm not sure that all of our precedents.
Yeah, I know. This is a long history on this case. I know I'm grown old doing
I
it.
have a factual question
Sure.
about the history.
Mhm.
I understand that the tribes were happy with the first programmatic agreement, which gave them control over certain land, et cetera.
Mhm.
And then there was a change where you still could have had the land, but the deal was they wanted you to give up sovereign immunity with respect to deeds or something. And I'm wondering, why didn't you take that deal? I guess you had two opportunities
Yeah.
to take that deal.
Well, right, and it can look like the tribe was being, stubborn. But what happened was when they negotiated that the tribes would be the conservators of these two properties, the land would not be in trust, and it had environmental, protection covenants in the agreement, and everybody signed off. And there was no need to have a waiver of sovereign immunity because in the agreement, if the tribe breached those conservation covenants, the land would revert to the federal government, not in trust for the tribe. So the tribe would lose all rights. And I think the state believed that if they didn't waive their sovereign immunity, the tribe somehow would get those lands in trust, in an Indian trust. But the Bureau of Indian Affairs, and you'll take my testimony on it, they won't take land in trust that have those kind of covenants on it.
So it wouldn't have cost the tribes anything to agree to waive the sovereign immunity because they didn't think they had a right to that land anyway. So why didn't they just?
No, the sovereign immunity, it's a waiver of their standing as a national recognized tribe, that they have their immunity is to protect their tribal assets. So
But
they
I
don't
thought
get
this was a
arbitrarily.
waiver only with respect to this agreement and the
Yeah.
certain covenants within the agreement.
Right,
And
but-
it sounds like they didn't think they were entitled to that land anyway, so I don't understand why they didn't.
No,
just
they
take the
were
deal.
entitled to be the conservators over that land. So they felt that the state was being unreasonable. See, they already executed agreement where the waiver was not part of the agreement. And the general counsel for federal highways argued with the state and said that waiver is not needed. The Board of Advisory Council on Historic Preservation said to the state that waiver is not needed. And so I think the tribe felt the state was way overreaching. And so then later, just so you know, the history is when they got into the arguments over the second programmatic agreement, the tribe offered that, said, well, let's get back to those covenants. Maybe we can do that. Rejected by
I
federal.
thought I read that it was offered to them again and the tribe.
No, the
rejected it.
tribe came forward and said, we will talk about that. We will put that in. And by that point, the federal government had excluded the tribe as a consulting party and refused to consider it. That's the record.
Mm.
Mm-hmm.
Okay, thank you.
But at that point, see, the
Ask you
reason they
about-
refused it is because they weren't going to go back to those mitigation properties
Yeah.
because the state was refusing to do it regardless. The state refused. What the state wanted at that point of the negotiation, it was a negotiation between federal highways and the state, is all they were willing to do was to give the tribe a video of its history, a documentary history, and training in 106 process, which the person that taught me all of this, the Tribal Historic Preservation Officer, was there at the beginning of the National Historic Preservation Act, at the beginning of the tribal program, and he really didn't need 106 training. So it was not.
That was where they started and maybe an unfortunate starting point, but then the highway administration did offer some other things and I thought offered two of the pieces of land, or at least guarantees of access for the tribe.
They still don't have access to that land.
Well,
there
that's
is-
because the tribe didn't agree to the offer.
Well, I don't think the tribe.
It was offered and then to protect your rights of access, and the tribe rejected that. Am I correct on that?
No, they never, they were supposed to have the management agreement of those properties when they first offered it.
Wait, if you're talking about the first programmatic.
No, yeah, but those properties that you're,
I'm on. So,
What, I'm sorry?
So let's forget everything
maybe I
that
missed-
happened under the first programmatic agreement. Pretend time started when they made the first offer under the second programmatic agreement,
Right.
the proposed terms for a programmatic agreement. And the first thing they offered for mitigation was the stuff you talked about, the training and stuff, and the tribe understandably said no. And then my understanding is that they came back and were offering, was it joint ownership or joint control over at least maybe two of the territories, two properties?
One property was going to be joint owned, but in the second agreement is what happened when they got to that point of the second agreement. The tribe was not a consulting party.
I got all that. I'm just
Yeah.
trying to ask you what the first mitigation proposal was rejected by the tribe.
Mhm.
And then the highway administration came back with another one. And that one involved the properties. I can't remember if it was joint, maybe not joint ownership, but there was certainly guarantees of access for the tribe. And it also was rejected,
Well,
correct?
no, when they came back with
What did
this-
they come back with?
They came back with no properties because the state controlled the properties.
You're not going to be able to own the
State
property.
would not,
What did they come back with? Not what they
they
did.
came back with, they would mitigate this with a video of the tribe's history, an academic
No, you
document.
rejected that one. They came back with other offers after that.
No, that's what they got. That was the agreement that was signed, the second programmatic agreement. I'm not making this up. What was signed by the state of Rhode Island and federal highways on the second programmatic agreement was the state was the conservator over properties. The tribe had no role in it. And they got a video. This is in the court's opinion. They got a video, they got a documentary history, and they got 106 process training. They didn't get anything else.
So I understand that the state offered a compromise of all three parcels in joint ownership.
Not on the second programmatic.
Spring of 2019.
I have to see that in the, well,
Anyhow, you can look at that.
the state never came back and said that they could be the conservators of those properties.
I'm not saying what they said. They offered joint ownership.
No. No,
That was not it.
no,
If I look at the record, it's not going to be there.
no. Oh, I can,
Okay.
yeah.
If a district court dismisses for lack of standing and doesn't expressly say whether the dismissal is with prejudice or without prejudice, what is it?
No, the district court dismissed without prejudice. So the plaintiffs,
I'm saying in general, if a district court dismisses for lack of standing and it doesn't expressly say with prejudice or without prejudice, what's the default?
well, the default here was,
Here in general.
well, I don't know if I can answer that because I think it's kind of has to be in context. I'm not trying to be difficult.
Isn't the default rule that if something is dismissed and they don't specify with or without prejudice, that it's with prejudice?
Right,
I think that's the default rule.
yeah.
I guess theoretically, if you're dismissed without standing, you could come back with additional affidavits or something if it were without prejudice.
But here, the court was, the opinion, when they dismissed without prejudice, they were very specific that the plaintiffs could go forward with the agreement.
Procedural.
Yeah.
In this case, I understand.
Yeah. Does that answer you? I don't want to.
It does. I mean, we have precedents where the district court dismisses for lack of standing, then that same party brings same suit, and the district court says issue preclusion prevents me from finding that you
Yeah.
have standing here. And your argument at the beginning of our conversation was that if it's dismissed for standing, it's just always dismissed without, or rather your argument.
No, what I'm saying is, from our perspective, when it was dismissed without prejudice for the second programmatic agreement, it made things easier for us because we could go forward on the second, which was a totally new initiation of a whole new 106 process. It wasn't a continuation of the first 106 process. It was a whole new initiation of a new process. Made it easier for us to go forward on that. And we did I inherited that complaint. I don't want to give excuses, but there's a complaint in the courts in Rhode Island that came forward. In the court, when they granted removal of the case into DC, they said it's ripe for summary judgment. I thought he had found standing. I was wrong. And so then when he dismissed for not having elaborated on our grounds for standing enough and putting in enough factual, we replet it to go after the new 106 process on the second programmatic agreement. And that made it much easier for us because that's what we are.
He's on a different legal theory about consultation.
Yeah. Yeah. I know it's complicated. I was trying not to get you in the weeds too deeply because we've briefed a lot of this, but I wanted to,
So you're way over your time here.
I want to get into the key issue, which is we feel the judge erred in failing to make the tribe a consulting party because this was off reservation land. That's a misinterpretation of the rules. That's the argument I want to get to, and I can do it quick.
Do you have any, excuse me, you're over your time here. And so
7 minutes.
it's going up now. The red means you're over your 10 minutes.
I'm sorry. I'm sitting there. I was not following you. You don't want me to get to the 106.
If you let me finish talking here. If you have, I will give you 2 minutes, but we have your argument from your brief. So if there's something more you want to add on from your briefs, then please, I'll give you 2 minutes on this merits.
After they are right
And
now.
I'll also give you rebuttal too, but just right now you can take 2 minutes
Yep.
to make this, what is your key point. But again, we do have your brief, so there's no reason to repeat that.
I know, but let me just summarize it. I appreciate the time. But again, I understand why the court below got caught up in the regulations and trying to understand this consulting party distinction. I think the government confused the court equating consultation as equivalent to being in a consulting party role. And in the rules, and this is in 800.2, and they have what is a consulting party? And when it's a tribe, what is a consulting party? And they said there's 2 times of tribes a consulting party, one when it's on tribal land, and then they talk about when it's on land historically significant to the tribe. And then it refers and this comes about, not in every stage of the consultation, it comes about once the parties agree that there's been adverse effects. And if there's adverse effects, do there need to be mitigation of those adverse effects? And once it's agreed by the party, there needs to be mitigation. That's when off tribal land, the tribe comes into a consulting party rule and they apply the MOU rules of section 800.6 that says the consulting party, the tribal consulting party is a signatory. And proof in the pudding is Federal Highways has done this with this tribe before. On other mitigation agreements, I have that as my Exhibit A, one in the city of Warwick and once on the same highway project. And they mitigated it by, one was improving the roof on a tribal longhouse and another, they actually gave them properties to conserve like they were doing here.
Yeah,
So
I got that.
that's I don't want to wear you out, but we feel that court.
We're not getting worn out here. It's
Yeah,
just,
I know. Well, I'm just saying that's where the court misinterpreted the rules.
yeah, I think we understand. You made the
Good.
legal argument in your.
Yay, well, I appreciate your time
Okay.
and
And we'll give you some time for rebuttal.
yeah, thank you.
Good afternoon.
Good afternoon, Your Honors. May it please the court, Dimitar Georgiev for the United States. Judge Walker, I'll jump right into answering your original question about the differences between, or lack thereof, rather, between the previous judgment decision to dismiss the previous case from the district court and the opinion below that is before this court. The way that the district court phrased its understanding of the complaint in the previous case appears, and we actually cite this on page 15 in our brief, and it states that the Narragansett claim that terminating the original programmatic agreement, that is the 2011 programmatic agreement, and dictating new proposed mitigation items that the tribe was never consulted about, is arbitrary and capricious. That is from the original case. So those, in that case, the district court found it does not have subject matter jurisdiction. We submit that the 2019 programmatic agreement was squarely before the court because the tribe raised it, and the court found that it lacks subject matter jurisdiction, and therefore it's
I think Ms. Walker's argument in response is that that first district court decision was a dismissal for lack of standing. It was a dismissal without prejudice, and that there's a kind of bright line rule that dismissals without prejudice don't have preclusive effect.
Two responses to your honor. First, that dismissal actually invited the tribe to amend its complaint. And so it could have done so to address the concerns that the district court had about subject matter jurisdiction. The tribe did not decide to do that. Rather, the tribe decided to file a new complaint, file a new case. And so we think that
So it amended it a lot.
I'm sorry, your
It
honor.
amended it a lot.
It amended it to the extent that it addressed some of the concerns that the district court had. However, under this court's precedents, under home builders, it doesn't satisfy the curable defect exception in the sense that the new facts that it brought into the complaint already existed at the time that the
So in
original.
home builders, I just went back to double check. The district court's first decision to dismiss for lack of standing in home builders did not specify with or without prejudice.
Correct.
And so Judge Pan suggested that that implies it was dismissed with prejudice.
That would be my understanding of this court's
Whereas
precedents.
here, the district court's first dismissal was a dismissal without prejudice. So I guess, do you have any precedent where a court found issue preclusion in the case before the court based on a previous decision where the dismissal was for lack of standing and the dismissal was without prejudice?
The question of issue preclusion was actually not before the court in this case below. So this is
I'm saying, do you have a preferably a DC Circuit case where you say, yes, there's issue preclusion here based on a previous suit that was dismissed without prejudice?
where that specific fact was what was outcome determinative, I don't have a specific site. However, under this court's,
Do you have any case where we applied res judicata or issue preclusion to a jurisdictional dismissal without prejudice?
so that begins with Dozier v. Ford Motor Company, and it continues with Gap Company, as well as most recently
Those
Home
were
Builders.
dismissals, okay. Sorry, maybe I didn't say it right. A dismissal for lack of jurisdiction without prejudice. Now, you just said Home Builders was with prejudice, or the court was silent.
I'm actually not sure whether the original dismissal in Home Builders was with or without prejudice.
Okay, so then.
I'm
that's
telling you,
not-
it was unspecified.
It was
I just looked it up.
unspecified. Okay.
So do
And
we
Judge
even,
Pan said that means with prejudice.
yes. And do we even need to reach this issue? Because even if we assume that you could assert issue preclusion, it wouldn't be precluded in this case because the previous dismissal, whether it was or without prejudice, was for a different reason. Like, so in that case, even if you assume that you could theoretically or not assert issue preclusion for something that was dismissed without prejudice, in this case, if we assume it were true, it wouldn't apply because on the merits, it doesn't meet the test because the first dismissal was for a different reason. It was because of alleged substantive injuries, and it expressly left open the idea that you could amend to assert procedural claims. And instead of amending, they just filed a new case that asserted procedural claims. It just seems like under the particular facts of this case, maybe we don't need to reach that technical question about whether the first dismissal was with or without prejudice.
I think that's right, Judge Pan. And moreover, I think the case would be different if there were facts alleged that occurred subsequent to the dismissal. That is not the case here. The only thing that the new complaint did was assert new facts or elaborate on facts that already existed at the time of the original dismissal, which under home builder puts it squarely within home builders, and therefore the court can rely on home builders and apply issue
What we're trying to
preclusion.
ask is, you're invoking not issue preclusion, but a curable defect doctrine. And I'm not aware of that being applied in cases that are dismissed for jurisdictional reasons without prejudice. And it didn't sound like you were either. You know, if someone keeps filing the exact same complaint with the same allegations, the same standing argument, and it gets dismissed, and then they add one new fact each time or something, that's a different story from what was going on here. But
I guess I don't understand your question.
okay, my first question is, it sounds like you don't have any authority for this principle that when you have a jurisdictional dismissal without prejudice, that the party can only replead brand new facts. That comes from a different doctrine, the curable defect doctrine.
Correct. That is home builders Dozier and then the progeny of Dozier.
Right.
Yes.
Okay, but that's a different doctrine, right? You don't have any application of that doctrine to a dismissal for jurisdictional reasons without prejudice. People replead to add facts, like a diversity case, and they got the amount of money wrong, and then they can replete it with the right amount of money.
Actually, that's Dozier, and that's precluded under Dozier.
If they knew it, or you could have a change in law, right? And someone has to add new facts because of a change in law. But again, I'm talking about a dismissal without prejudice, which is not
In
cases you're citing.
even if the court declines to apply issue preclusion and looks at standing directly, the tribe doesn't have standing to bring this
Okay, just one other
particular
thing.
case.
Did you raise issue preclusion before the district court?
It was not argued before the district court. It was included in the answer.
Right. Okay. All right. That's right. I remember that now. Thank you.
And even if the court doesn't apply issue preclusion, but reviews the tribe still lacks standing, particularly what the tribe has asserted is that vacature of the 2019 programmatic agreement would lead to a new process that would necessarily lead to some alternative measures. The only three alternative measures that the tribe has put forward relate to the acts of a third party that is not before the court, and that is the state of Rhode Island. They've asserted that the state of Rhode Island can still transfer the properties to the
We're
tribe.
very much objecting to the amount of consultation process received from the Federal Highway Administration. They're very much objecting to that.
Right, and the question,
That's not something Rhode Island is in charge of delivering. That's something the Federal Highway Administration is in charge of delivering.
the act is an act that guarantees process. It doesn't guarantee outcome.
Okay, that's a merits
Ultimately,
argument, right?
yes.
Yes.
What the tribe has identified as three possible outcomes of that consultative process is that they can obtain the three properties that were issued in the 2011 programmatic agreement, that the federal government can essentially write a check, provide them with funds, and for the tribe to come with some sort of mitigation on its own, or some other unspecified mitigation. For the Rhode Island to transfer properties, necessarily that is an act of Rhode Island. And the federal government has attempted numerous times to compel Rhode Island to adhere by the 2011 programmatic agreement. However, Rhode Island refused to do so. And there's no evidence in the record that the tribe and Rhode Island can come to some sort of mutual agreement to transfer properties from Rhode Island to the tribe.
The Highway Administration here, when put aside the whole first programmatic agreement. So it was going back to the drawing board and starting now with the second programmatic agreement. It opened by sending an email to the tribe that says, here's what we propose for mitigation. And it was, y'all need training. We'll have a little historic program. Pretty pathetic. And the tribe felt insulting. Not an unreasonable response. Why did you not have an obligation before throwing out to them, here's what we're going to do for mitigation? Talk to them before you made any mitigation proposal. Isn't that what the consultation? I'm not saying whether you had to agree with what they're proposing or not, but it seems like you sort of set them out. Here's what we're offering before talking to them. And then you said, react to what we're proposing. Does a consultation process require you to talk to them first?
The consultation process requires the solicitation of the tribe's views.
At what stage?
There are actually 4 stages throughout the process that are outlined in the regulations. Here, we're only talking about mitigations. This was in initial.
Before you propose mitigations?
It is whether the agency or the state or the tribe first proposes mitigations. That is an initial proposal. And that's actually what happened. And I would like to.
Sorry, I'm trying to get just a clear answer to a very specific question.
It was
before the June 28, 2018 email that said, we're starting over, we're starting from scratch, new agreement, here's what we propose for mitigation. Was the tribe consulted before you formulated those proposals for mitigation?
So the tribe had been engaged continuously for numerous years.
I understand that was all under the first programmatic agreement. Did you consult with them about the mitigation that was proposed in the June 2018 email?
The record doesn't indicate whether the agency directly engaged with the tribe on those specific proposals before June 2018. However, the agency did engage with the tribe and listen to the tribe's inputs afterwards.
I don't know, I'm just asking. So, okay, so let's take, so the record no evidence that you consulted with them before the June 2018 email.
Correct.
Which was here's what we're going to do for mitigation now. Does the consultation requirement at this stage, the mitigation stage, require you to talk to them before you start putting pen to paper and settling yourselves on particular ideas about what you think the mitigation should be?
The regulations do not specify exactly at which point in which email, before which email.
If you can just tell me if this is a practice, I don't know. Do you routinely do this? Do you say, here's what we think is good mitigation, react? Or do you usually, I had thought the government usually talk to the tribe, and maybe other interested parties too, but we're only just talking about tribe here for this. Talk to the tribe before proposing mitigation efforts. That was the usual practice.
So
is that the usual practice?
I am not familiar with every single instance. However,
okay, I'm not asking every single interest. I'm asking usual practice, which there could be exceptions, but is that the usual practice?
I apologize, Your Honor. I don't know. I'm not sure it's exactly at what point, whether
isn't that kind of important here? I mean, if it's a consultation, right? And at least it sounds to me, but I might be misreading the regulations here, that maybe the most important stage is to talk to them before people start locking into certain ideas of mitigation.
I think what Your Honor is assuming that proposal is what ended up in the final agreement, which is what.
No, that's not my assumption. My assumption is that, and none of this is criticizing what the Higher Administration did with respect to the first programmatic agreement. Sounds very frustrating, pulling out hair, very unfortunate developments, but put that all aside. And now you've at some point someone said, let's start this process over because we got to fix this bridge. On what authority was the Highway Administration relying when it said, fine, we're gonna have this list of 3 mitigation, I think it was 3 mitigation things, and we're gonna put it out there and say, react, without talking to them first? first talking and then factoring that information in, not bound by it, but factoring that into your decision-making in formulating the initial proposal of mitigation efforts, the starting point of the discussion. Why, I'm asking you to explain to me why that isn't how it happened.
I think what is driving this specific case is the fact that there was so much discussions prior to that
That was
June.
about just a different thing. It ended up being something that just seemed very promising at the beginning, and then Rhode Island, pulled the legs out from under the table. But tell me, on the first programmatic agreement, did the Highway Administration consult with the tribe and maybe also with Rhode Island? Again, this is not to the exclusion of others, but did it consult with the tribe before coming up with mitigation proposals, even as a starting point?
The record doesn't indicate one way or the other. In the joint appendix, there is no evidence when the exact contours of
I would have
the.
thought the Highway Administration would know what it did, but okay. All right.
I think what's important, even assuming that there was an obligation to consult with the tribe before that initial proposal was made, the evidence clearly shows that the tribe was invited to and provide input. It provided input, and actually to those specific proposals that the tribe found were insulting, those did not end up in the final
I know, but
programmatic
it's
agreement.
just a whole different thing when you start from a point of insult and then work from there, as opposed to start from a point of discussion and work from there.
And the
I would have
original.
thought the point of the statute was the latter.
The point of the statute is to solicit the tribe's views.
Exactly. Before the administration makes a decision. And a proposal is a decision. It's not locked in, but it's a decisional stage.
And the unfortunate reality of this specific case is that there was a programmatic agreement in 2011 that everybody agreed to, and that Rhode Island.
I understand. I think we all know that history. That's not the question. I'm asking a legal question about your obligations.
Nothing in the regulations,
Compliance with
nothing,
your obligations in this case.
nothing in the regulations, nothing in this court's precedents requires the agency to engage with the tribe before putting forth a proposal that invites
Is
the.
there anything that says you don't have to? Or are you just telling me there's just a vacuum of information on this?
It leaves it purposely vague to allow the agencies and the tribes and all interested
What's your
parties to
best
engage.
case for it's purposely vague and you get to choose when you're going to start consulting? What's your best case for that?
So the Eagle County actually in this from a couple of years ago from this court actually specifically stated that
I'm sorry,
there's.
doesn't the regulation say whenever an agency official proposes a programmatic agreement, the agency official shall ensure that development of the agreement includes appropriate government to government consultation. So it seems like you do have to consult before you propose
It is
the development of the agreement.
It is in the development of the agreement. Exactly. It is after there is a proposal that.
Wait, a proposal isn't part of developing an agreement?
Sorry, Your Honor.
A proposal is not part of developing an agreement? I would have thought it would be maybe one of, the starting point and the ending point would be the two most important ones.
And that will be the beginning point. And that is when the consultations begin. That's when the tribe's views are solicited. The tribe's views here were solicited and they were listened to. And those initial proposals were rejected and they were not included in the ultimate programmatic agreement that was signed. And that is the Joint Appendix 396. That programmatic agreement, the 2019 programmatic agreement, provided that the three properties the tribe was most concerned with and that were subject to the 2019 programmatic agreement would be preserved by the state and they'll be managed by the state. And the tribe would be permitted access to those properties.
I think my colleagues don't have, we haven't gone good with our time with both of you. We keep keeping you up here longer than we promised. Do you have any more questions or? Okay. Thank you very much, Council.
Thank you. We ask that you affirm.
Ms. Walker, we will give you 2 minutes.
I'm going to refer you to the JA 80, which is the handbook that HIP puts together trying to help with the consultation process. Now, if you know the consultation process or the whole historic preservation program, this handbook helps you, but they don't cite to code sections in the handbook. But on page 8, it says tribal consultation should commence early in the planning process in order to identify and discuss. This is all through the regulations. They're recommending when they start consultation.
Which page is
This is on JA 80, and it's a bullet. It's on page 8.
Yep. Okay.
Tribal consultation shall commence early in the planning process. So again, I wish this were simple, but there's a lot of places where the tribe is important to consultation. And one is when they are starting an undertaking and they're trying to identify if there's historic properties. They get the tribe, if it's going to be, if they believe there may be a tribal historic process, the tribe is to get in the process of consultation early with the agency. Then the tribe is in consultation when they decide, well, okay, the undertaking may impact, but does it have adverse impacts to the historic property? Tribe is supposed to be in that part early. And then when they also are supposed to be early when the agency, the undertaking, they're looking at what the construction of the project would be. All of those stages, the tribe is to be in. Now, when it's on tribal reservation land, it's very easy to understand the tribe's going to have a primary role. But considering how little property Indians in this country have, how much they've lost. You know, there's a lot of historic sites, Indian sites off reservation lands. When a tribe has a significant role in mitigating and negotiating those measures, that's when all the parties agree that there has to be mitigation of these adverse effects. An agency can come in and say, well, there's effects, but there's no harm done. But when they all agree there is, sir.
If we think of the planning process as ending when a final decision has been made, how long was the planning process here?
Oh, well, this highway project, the first agreement was negotiated in 2013. The project had started 2011 when the consultation.
Sorry, I could have been more precise with the question.
Yeah.
If we think of the final decision as the second programmatic agreement, when did that, how long was that planning?
Well, they terminated the first agreement. I think it was officially terminated in like January of that year. You're talking about 2018 or, June 20th, whatever, that 19 when it was signed. So it was November is when things broke down, they terminated. So what happened in answer to Judge Millett's question is the state and the feds were consulting on what the mitigation measures would be, and then just presenting it to the tribe as if that were consultation. But in this role, where it was a programmatic agreement over a complex project because they had decided they had to go into subpart C of the act because this was a bridge that had long impacted this property. It would cost too much to do all the excavation and evaluation of damages. So they had a very complex agreement. They went to the programmatic agreement.
Okay.
And in that stage where they all agree, and I'll read it from, this is part of the JA, this is on page 26 of this handbook, which is, let me see, JA 9998. But it says, if an agreement is reached, the agency and SHPO and consulting parties, including Indian tribes, to develop a Section 1 memorandum agreement or program agreement outlining how will the adverse effects will be addressed. And so what it goes to is that this is on page 27, I'm losing myself here. Then that's when the tribe becomes a consulting party. So the tribe is not just being consulted, it is a negotiator in the mitigation agreements. You can't exclude them from that. That's not what the rules say.
Go ahead.
And that's what happened here.
I think there is some support in this regulation 36 CFR section 800.14F for Judge Millett's suggestion that maybe you have to consult before you propose. Because
Oh, yeah, absolutely.
consultation with Indian tribes and Native Hawaiian organizations when developing program alternatives. That's what it's called. Whenever an agency official proposes a program alternative pursuant to paragraphs A through E, the agency official shall ensure that development of the program alternative includes appropriate government-to-government consultation with affected Indian tribes and consultation. So that suggests that before it's proposed, when you're developing it, you have to consult.
Exactly. That's what I'm trying to say is that when they identify that they're going to, like here, expand this bridge project.
But I guess the question is whether it's adequate to the whole prior discussion that they had. Is that adequate to satisfy?
No,
800?
that was the consultation on the first programmatic agreement. The second programmatic agreement, when they reinitiated the 106 process.
I think
they-
it's like a factual issue, like whether that
Yeah.
can count, like everything you did with the first.
Well,
Is that
that's what the
consultation for
government
the
wants to
second?
say, that they consulted and the tribe was a party, but that was the first agreement, not the second agreement.
But
Second
both
agreement,
agreements were about the same bridge.
same bridge and an expansion of the bridge in Providence. The original bridge was over this Covenant's property that had caused all this 30 million or something, they think, in damages. And they were expanding it. So under subpart B of the process, you have to do all this architectural review and evaluation, and the tribe's all a part of that. But they didn't do it because they all knew the
About
damage.
what year did
Oh,
the government, the agency, become aware that the land was special to the tribe and the tribe would like other land kind of as a swap?
well, this bridge expansion project started in 2011, resulted in a programmatic agreement in
Can
2013,
you just please answer
Well,
the question?
that's when it started.
What was the year when the agency?
2011.
That's who, in 2011, the agency was aware because the tribe told them this land is special and we would like other land in exchange for it.
Well, actually, the feds and the state came to the tribe with that proposal, which was agreed to by the state of Rhode Island, the tribe, and federal highways. The tribe in the first programmatic.
By 2011, the federal agency knew the land was special to the tribe and the tribe would like other land as mitigation.
Yeah, they offered that.
So since 2011 is well before the proposal for the second programmatic agreement, it seems to me that the government, the federal agency, consulted with the tribe well before the proposal for the second programmatic agreement.
Yeah, but you can't collapse that. When they started the second, they terminated the first. When you terminate it, then the agency has to reinitiate the Section 106 process, which reinitiates the consultation. So they knew, and the tribe's not arguing. I'm not arguing with you that they didn't get consulted.
Like, I mean, they continued to consult with the tribe after they proposed the second programmatic agreement. That's, we all agree with that, correct?
Yeah, because
And then the question is, did they need to consult with the tribe before the proposal for the second programmatic agreement? You say they did need to do that.
yes,
And I think part of the government's argument is they did consult with the tribe before the second programmatic agreement's proposal because they had been consulting with the tribe since 2011.
oh yeah, but Judge Walker, this is the distinction I want to make, is the tribe was not a signatory or a party to the negotiation of those alternative measures for the second programmatic agreement. The first programmatic agreement, they were signatories and consulting parties because that's what the rules require. And the
You're
second,
stating facts from the record that I know.
I know,
And,
I know.
and
but this is
I don't even hear
significant.
you arguing here that they today and
No,
that
yeah.
they needed to be a signatory to the second.
They did,
programmatic
that's what-
agreement. You argued that in the brief, that they needed to be a
Well,
signatory.
that's what I was trying to get to.
But the question that we've been discussing is, regardless of whether they needed to be a signatory to the second programmatic agreement, had the tribe been consulted before the second programmatic agreement was proposed? And it seems to me they had been consulted for years
No,
before the
no,
second programmatic
no.
agreement.
No, I disagree. And I'm not trying to be
I'm asking for
argumentative.
your.
No, I disagree.
You can be argumentative.
I know, but I'm not trying to be contrary, I guess is the word. But what I'm saying is where the tribe consistently complained was they weren't, because they weren't consulting parties, the state and the feds were deciding what the mitigation measures would be. And the tribe was complaining, we would never accept that. But they weren't brought in as a negotiator, as a party to
They
execute
were,
the
they were
agreement.
complaining before this, the second programmatic.
Yeah, because
agreement was
they were just
proposed.
being,
They were complaining before the second programmatic agreement was proposed.
yes, the
They were
records,
complaining they would not
they were complaining.
accept, they would complain they would not accept what ended up being proposed.
Yeah, they complained that they
That
wouldn't
seems
accept
like,
it.
that seems like the federal agency heard loud and clear from the
No,
tribe.
we're not
before the
saying
second programmatic
they
agreement was
weren't
proposed.
giving the tribe information about what the state and the feds agreed to as mitigation measures. The difference is if you are a party brought in to be a negotiator on those, they can't sign off on that agreement if the tribe doesn't agree also. They all agreed on the first programmatic agreement. The state reneged and that was over. The second programmatic agreement, this is so important.
That tribe was not a signatory for the second programmatic agreement. You say in your brief that the tribe had to be a signatory for the second programmatic agreement. I get that you think that's important, and I get that that's an argument that's been briefed. But I think we've been talking for quite a while about a different legal issue, which is not about whether the tribe needed to be a signatory for the second programmatic agreement, but whether the tribe needed to be consulted before the proposal for the second programmatic agreement, and whether they were consulted before the proposal for the second programmatic agreement, and whether the discussion between the tribe and the agency during the first programmatic agreement would count as consultation with the tribe before the second programmatic agreement was proposed, right?
Right.
Okay.
My view, our view, I think the tribe's view would be the consultation had to start anew. The
So-
agency can't collapse the consultation before onto the second
I think we
agreement.
should look at what the district court found. Because the
Yes.
district court found that the consultation was adequate, and apparently it didn't rely on the consultations with respect to the first programmatic agreement, because it starts the discussion by saying, as early as June 28th, 2018, the agency informed the tribe it was initiating a new programmatic agreement. And then the tribe responds September 10th, 2018, that it was inadequate. When was the proposal actually made?
Well, the proposal was between, they beat around the bush several different proposals.
June 2018 was the first
Yeah,
proposal.
June
So that
2018.
was the proposal.
That was
So
the final
according to the
petition.
district court's findings, the district court found the consultations were adequate, but didn't rely on prior consultations with respect to the first
Yeah.
programmatic agreement.
Well, I'm not disagreeing with what they found.
This court didn't find any consultations with the tribe prior, once the first programmatic agreement was terminated before the June 2018, the tribe did not participate in the formulation of the June 2018 proposal.
Exactly.
That's factually accurate?
That's
And the
accurate.
district court did not rely on that.
Yeah.
Were they
Didn't
offered
find-
the opportunity to participate?
They were only presented what the state and the feds agreed to as this is what we want to do. And
The
the
state and
tribe,
feds were talking first, and then, okay.
yeah.
Any other questions?
And I know, I don't want to keep repeating myself.
No, I think we've been able to clarify it.
No, but it is significant what the tribe is standing for and what the 33 other federally recognized tribes that filed an amicus on this brief are standing for.
Yes, I think, sorry,
So
we got their amicus brief, we have your brief, your
They're standing for the-
Your 2
I know,
minutes.
but they're standing for the fact they're required to be a signatory.
Okay,
Yeah,
Thank
thank
you.
you.
with that, the case is submitted. Thanks to both counsel.
This honorable court now stands adjourned until Tuesday, October 23rd, 7:30.